Someone make it make sense.
Probably a couple.
Hello. We are here to wrap up the last day of the Sarah Boone trial. We're going to actually pick up with the jury instructions. The beginning of day 6, they started out with the charging conference, or at least they got started with it. And then they had the state rested their rebuttal case after reading a bunch of those text messages into the record. Now, I did actually cover those live when it happened, so I'm not going to go over those again today, but that live stream, of course, is in the playlist along with everything else for this trial. So we're going to pick up actually with the jury instructions, followed by closing arguments and the verdict. So let's go.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Everyone can be seated. Thank you. Members of the jury, thank you for your patience. We had a long conversation about the jury instructions, and I missed a typo or two after I had printed everything, and took us a while to print everything out. I'm going to ask the court and deputy to come forward to pass these out to you. If you can, please raise your hands to confirm that you complied with the court's instructions during the break. All right, record reflect all hands have been raised. Members of the jury, we are at the conclusion of the evidence and testimony in this case. The court is now going to instruct you on the law. The courtroom deputy is providing you copies of the jury instructions. Like I said at the beginning, you're going to be able to take these back with you into the deliberation room. There's not going to be a quiz or a test at the end. You don't need to memorize anything. If you'd like to read along, you can. If you just want to listen, you can. It's completely up to you. Court's going to read most of the instructions and then turn it over to the lawyers for their closing arguments. The state will go first, as they have the burden. Then the defense will go. And then the state will have the opportunity to rebut. Then I will conclude the instructions and release you for your deliberations. After the state's closing, we're going to take our afternoon recess. At that point in time, I'll have the courtroom deputy provide you that emergency number. So if you need to reach out and do family or loved ones to let them know that you are on the jury and are deliberating, you can do that at that time. With that, members of the jury, the court's going to go ahead and begin reading you the jury instructions. Instruction 3.1, introduction.
I will say real quick, sorry for that terrible pause.
To final.
Why? Okay. So one thing I will note is that prior to the jury instructions being read to the jury, they had discussed scheduling and a number of other things. And one of the things that Mr. Owens had raised was that they wanted to split the defense closing. And I've only ever heard that asked one other time. And that was, well, actually, I feel like maybe they did ask that in Murdoch, so that would be 2 other times. But they definitely asked that in the Ezra trial, and it was, denied. And so he said something like, Mr. Henderson would like to also add some remarks or whatever, and that was denied. But that gives us a little preview into what we might be seeing going forward when it comes to the defense closing. So that also had already happened. And then the other thing is that they had discussed scheduling, and the plan was that they were looking at the timing, they were expected to be done with closing arguments by 5. That was the plan. So that also will come up when we get to the closing arguments and looking at some things here with Mr. Owens. And the other thing that had happened when they were doing the charging conference was that they had added a lesser included of culpable negligence. So, but we'll hear him read that in the instructions.
Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. 3.2, statement of the charge. Sarah Boone, the defendant in this case, has been accused of the crime of second-degree murder. 7.1, introduction to homicide. Sarah Boone is accused of second-degree murder. Murder in the second degree includes the lesser crime of manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find George Torres was killed by Sarah Boone, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder or was manslaughter, or whether.
One other thing I'll note really quickly is that there have been a lot of people talking about her intent. Did she intend to kill him? Did she not intend to kill him? And that to me seemed like a reasonable question to ask oneself when determining her responsibility prior to the trial, right before all this other evidence came in. However, when I first did the very first recap on day one, or rather, I guess it was the opening statements, I pulled up the statutes for both second-degree murder, actually first-degree murder, second-degree murder, and manslaughter in the state of Florida. And I pointed out that nowhere in any of those charges does it use the word intent, not once. So I pointed that out because it was still something that was kind of being discussed, but they don't, intent in the state of Florida is not a part of first degree, second degree, or manslaughter. So that's why part of it is so ironic. How many times does she say not intentional? Because she incorrectly assumes that that would make a difference without knowing the law. Of course, that's completely irrelevant. So we'll hear this as we listen to these jury instructions. Let's listen for how he handles intent. Okay.
The killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm.
Think about that when it applies to this case. My thought is that we're going to hear about well, he won't be able to say bat specifically, but I'm sure he will define that as we go along. But when we think about great bodily harm, when we think about a dangerous weapon, the design of that weapon, I think, a bat, obviously, that's what I'm thinking here.
Harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. I now instruct you.
I've referenced this. So the standard for great bodily harm does not include mere bruises. Let me back it up so we can hear the full definition again.
Great, as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises.
Okay.
I now instruct you on the circumstances that must be proved before Sarah Boone may be found guilty of second-degree murder or any lesser included crime. 7.4, murder, second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, George Torres is dead. 2, the death was caused by the criminal act of Sarah Boone. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life.
Well,
An act includes a series of related actions arising from.
I'm putting together the elements as we've done in all the other trials. I'm putting together the elements and I'll put those on the screen. So hold on.
Beyond a reasonable doubt. 1, George Torres is dead. 2, the death was caused by the criminal act of Sarah Boone. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause
There
death.
it is. There it is.
3.4, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is charged, there may be evidence that she committed other acts that would constitute a lesser included crime or
Okay, he's
crimes.
going to go through manslaughter.
Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of second-degree murder is manslaughter, culpable negligence. 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, George Torres is dead. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Yes? I apologize. 4, thank you for that clarification. Sarah Boone I'll reread those for you. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. Or B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation.
So I'm going to back it up just so, again, I'm typing this up. So, but here's the difference. So you might have heard the word intent here, but this isn't intent to kill. This is intent to commit an act. Okay. So in other words, she did intend to have him zipped in that suitcase, right? So that, again, that's where intent to kill is completely relevant here. The intent here is committing an act that then leads to death. But I'm going to play it again so I can get this languaging and put it on the screen for you guys.
George Torres. Or B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty. I apologize. 4, thank you for that clarification. Sarah Boone I'll reread those for you. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. Or B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I've previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Capable negligence is a course of conduct showing reckless disregard of human life, or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known, or reasonably should have known, was likely to cause death or great bodily injury. 8.9, culpable negligence. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Sarah Boone exposed George Torres Jr. to a personal injury. 2, she did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm.
Back that up just 1 second, typing it up here.
Torres Jr. to a personal injury. 2, she did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life, or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such indifference to the rights of others as is equivalent to an intentional violation of such rights.
All right, guys, I've got the elements on the screen for you. I'll just read them over quickly so we can, actually, let me hide it and show it. So we'll start over so we can take a look here. So elements of second-degree murder. 1, George is dead. 2, death was caused by a criminal act. 3, an unlawful act imminently, that unlawful act just referenced in number 2 has to be imminently dangerous and demonstrating a depraved mind. Elements of manslaughter. 1, George is dead. 2A, Sarah intentionally committed an act or acts that caused death. Or B, the death was caused by culpable negligence. And remember, the intent only applies as it only applies to the act itself, not the intent to kill. Elements of culpable negligence. 1, exposed George to an injury. 2, did so through culpable negligence. And I think that's about it for the elements so far there.
3.6D, as in Delta, voluntary intoxication. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. 3.6F, as in Foxtrot, justifiable use of deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use, deadly force, is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself.
And this is the same languaging that we've talked about, like especially when it came to Ezra. I've discussed this a lot about how this is the standard instruction for self-defense, right? That you have to have a reasonable belief that amount of force is necessary. Now, I'm sure he'll describe also where battered spouse comes in and the differences, but that's the standard threshold for regular self-defense. Why, spinny wheel? Why? No, don't do this.
Sarah Boone had no duty to retreat before using deadly force. In deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself, unless 1, the threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. Please silence your cell phones.
Oh, this is when the jury gets in big, or
and
not
had exhausted every.
Sorry, the gallery gets in big trouble here, as they should.
Out.
Yeah,
She's got her phones on. Get out right now.
Get out right now, he says. No, ma'am. No, sir, whoever it is. No phones.
Members of the jury, I apologize. I'm going to read that over for you from the beginning. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm, and had exhausted every reasonable means to escape the danger, other than using deadly force on George Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed the threatened use of force. Physical contact includes any restraint on George Torres's movement.
Well, there you go.
If you find that Sarah Boone, who because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
I'm missing page 10 and 11.
I am too.
Oh boy.
We will remedy that. Thank you, sir. Is it just your copy, Mr. Owens?
Anybody else missing 10 and 11?
Mr. Owens, approach, sir. Yes, sir. We'll bring it to you, sir. And we'll wait till after the sir will continue. Thank you.
By the way, guys, from what I've heard, this jury, remember, there's 6 that end up being deliberating jurors. From what I've heard, it was 1 male and 5 females, or 1 man, 5 women.
Thank you. Record reflect all thumbs were up. Page 11, special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible.
Oh, here we go with battered spouse. Yeah, Candace says, I don't think I've ever heard a judge say, get out right now. Yeah, so the thing is that, like, I don't know if anyone else has noticed this, but there's been cell phones going off pretty regularly throughout this trial. Almost every day, I think there's been some phone in the gallery has gone off. And everyone the judge hasn't said anything. I think maybe one time he says, please silence your cell phones, but for the most part, they just kind of ignore it. The witness looks over confused and then they just keep going. But this has been an ongoing thing. And he's actually not been giving that like, at least not with the court feed, on the record with audio. A lot of times, like we'll hear in trials, the judge on a regular, like on a daily basis, address the gallery and say, okay, here's the rules for you. Do this, don't do that. No phones, blah, blah, right. We've not heard any of that. But it's been an ongoing issue. And then the difference here is the jury instructions are so crucial. And he's been incredibly patient about this issue, right? And who knows if it's the same person or not. But it happened once. He says, please silence it. And then the second time, get out right now. Now, I will say that there's been plenty of trials that I've seen. Like the vast majority of trials that I've seen, if a phone goes off one time, I don't know. I think that whether the judge says get out or bailiff, please, or the bailiffs are just instructed ahead of time. Usually what happens is if there's any phone once, they're escorted out by the bailiff and cannot come back to the trial, like period. I'm trying to think what trial it was where they actually would take your phone. What was that? Might have been Lori Vallow, actually, which we know it was audio only. But with that, I'm pretty sure that's what it was, where literally if your phone went off one time, they would take your phone. And like, there was like, apparently they don't actually like have to give it back to you, which is insane. So I think it was also applied if you were seen using your phone, the bailiff would come and take your phone. So this judge has actually been really patient and lenient with the phone shenanigans compared to what I've seen. Deputy Heard is another example. I think there was 1 or 2 days where there was something with a phone and same thing, like get out. So, but yeah, I mean, he did have a stern tone, but it was warranted, in my opinion, for sure.
Credible. You may consider this evidence to assist you in determining whether a person,
considering it wasn't the first time, right?
in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.6G, justifiable use of non-deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. The law on the justifiable use of non-deadly is as follows. Sarah Boone was justified in using non-deadly force against George Torres and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against George Torres'
And what I will
imminent
do
use
is when he gets to the justifiable use of deadly force, I'll put that up on the screen.
of unlawful force. In deciding whether Sarah Boone was justified in the use of non-deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of non-deadly force was necessary. Moreover, a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. However, the use of non-deadly force is not justified if you find that Sarah Boone used force to initially provoke or threaten use of force against herself, unless the threatened force asserted towards Sarah Boone was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on George Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and indicated clearly for George Torres that she wanted to withdraw and stop the use of non-deadly force. But George Torres continued or resumed or threatened use of force. Physical contact includes any restraint on George Torres' movement. If you find that Sarah Boone, who, because of prior threats or difficulties with George Torres Jr.
One thing that I feel like I must be missing, like, has no one brought up somehow, like, okay, I've brought up, and it's been brought up, or suggested so far in questioning, and I'm sure it'll come up in the closing arguments, about how the fact that he was in the suitcase, right? She had the phone, she was filming twice, and somehow miraculously this supposed threat happens in between those two videos when she has her phone but isn't filming. But has anyone brought up the fact that we know she had her phone with her and she didn't call 911, like call law enforcement? Like, what I mean is that he's in the suitcase, right? She's like thinking that the threat is over, but also not. It's contradicting because she leaves a hole where his hand can get back out or whatever, right? Nonetheless, never ignoring all of that BS with the problems with her story. You know, if he's in the suitcase, right, and you've stopped a threat or whatever, you feel like you're in danger, but at least he's contained, right? And we know you have your phone. You didn't call law enforcement when law enforcement literally would have you like on speed dial, right? Like what made me think of that is like the other options, right? The less lethal options, and he's not even gotten to deadly force yet, but the other options available to you, like leaving wouldn't be really applicable to her because she lives there, right? So, you know, whatever. But calling, we were like, again, in the Ezra trial, I keep referencing because that was self-defense as well, or that was their affirmative defense. You know, one of the things they kept bringing up is how she didn't have like a working cell phone or whatever, and there wouldn't have been service to use his phone or whatever to try to, you know, get ahead of the fact that she didn't call 911 when that's what a reasonable person would do. But it's interesting that in this case, like Sarah had a working cell phone. She was using the cell phone. She had service like this. So none of those scenarios apply in this case in regards to the phone. But instead of using the phone to call law enforcement, she uses the phone to video him a second time. I just feel like, has anyone, I feel like that hasn't been really brought up a whole lot, but it is a good point to think about.
Had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres Jr., you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder and or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.7, plea of not guilty, reasonable doubt, and burden of proof.
Oh.
The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9 Bravo. Defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to: 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. 3.10, rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice.
So the significance about that promise bit, right, as it applies to Sarah Boone, that's why they really, when she was on the stand, really tried to emphasize this point about her picking up her cell phone, right? That I think would be the promise. Like the promise, although it wasn't really a promise to talk to them, it was more like a way to lure her to get her to come over or whatever. But I think that's part of what they were trying to do there. However, you know, it was pretty clear. Well, Sarah kind of didn't do herself any favors and contradicted that herself when she said, you know, she's on the stand, and then she said that she felt like Detective Copsall was being dishonest with her. So it was like she wanted to get her phone, but then she's like, I felt like she was being dishonest with me, so I wanted to talk to her. So, again, and I believe that. I think that was like a mistake. She didn't plan on saying that, but like, yeah, she wanted to talk to them to figure out what they knew. She wanted to talk to them to figure out if she was going to be arrested. And she, stayed in that room as long as she did, seeking confirmation or seeking affirmation, that type of thing, which of course she never got. So
there is no reason for failing to follow the law in this matter. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision, in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced.
I appreciate, it's funny. My previous live stream from like yesterday, I guess it was, I covered the latest documents out of Idaho, and I've been talking a lot about trial procedure and bifurcated or trifurcated trials and the nature of sentencing. And when it comes to death penalty, especially non-statutory aggravating factors, non-statutory aggravating evidence. However, that's also applicable when it comes to any trial, even if it's not death penalty or whatever, because that mostly refers to victim impact statements. And so anyway, just thinking along the lines of how can you get the jury to do their job, which is render a verdict based on the jury instructions, the elements of the crime. So I just wanted to say that I appreciate that when they render their verdict, obviously they're not going to be influenced by any emotional statements. That's part of why they, had that issue, which, whatever, we'll get to it with the mom. But I also appreciate that the jury does not know what the penalties are for the different, there's the lead charge and then the lesser included. They don't know what the penalties are. They don't know what the possible sentencing options are. And I think that's really important because if a jury is trying to determine, if we're in the guilt phase, right? And they know, okay, here's how many years for this, here's how many years for this, here's how many years for that, then that could influence, right, their verdict. So I think it's important, and I just wanted to point it out. I think it's really important that when a jury is determining a verdict, and I think the same if they're determining a sentence, for example, in a death penalty case, or in the very rare occasion, like in Mississippi, where you have a state where the jury does determine the sentence, even if it's not a death penalty case. We saw that with Carly Gregg. I think it's important that the same type of thing applies where they're looking at the facts, objectively, information. Here's what the law says. Here's what the statutes say, anyway, but I just wanted to point that out that, because if a jury is determining a sentence, then obviously that changes that's going to be a part of it. But, I still think that it should be done based on the law, based on the statutes, based on the rules, and based on their instructions. So anyway, for more on all of those issues, do check out the Brian Koberger playlist check any live stream where it's dealing with the death penalty motions, and you will definitely hear more elaboration on the different factors to consider, especially when it comes to a death penalty case.
Influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. 3.11, cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. 2.7, closing argument. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. With that, state, you may proceed.
That's interesting. Oh gosh, that's okay. Wow. It's interesting that there's a time limit because I guess the sense would be the time limit is for the state, but not for the defense. But the thing that's interesting is that these went way longer than anyone anticipated. So I think what happened was Owens was allowed a certain amount of time, but said he wasn't going to use it anyway. But that's what I was talking about with the scheduling, because it was expected that closing arguments would be done around 5, and then the jury would be given, would be sent to deliberate around 5 o'clock. So, and it was like way, I don't even know. It was like after 6:30 or something. It was crazy. So maybe even later. But okay, now we're on to the state's first closing argument. Brilliant. Starting with the suitcase.
This is a box. This is the box where George Torres was killed. It's a small box, 28 by 20
Powerful.
by 8 7/8 inches. George Torres was zipped up in this box. George Torres took his last panicked breaths in this box. The medical examiner explained to us that with each breath George Torres took in, there was less oxygen in this box. George Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things. And if
This is really important, and I'm really glad he's pointing this out, because this is a really huge part of any instructions, any statutes. The law is full of this, and you wouldn't necessarily know the importance of it unless you are like an attorney or work in the legal field, or if someone tells you. And I don't know that I've really ever heard in closing arguments, I don't know that I've ever heard any, whether prosecutor or defense attorney, I don't know that I've ever heard this explicitly pointed out to the jury. And I feel like it should be, so good for him.
nor is there that only one of those things we're going to need.
Mm-hmm.
So as we start out here on Introduction to Homicide,
Oh my God, look at their ELMO. Dude, they have a high-tech, can you guys see my mouse? Look at their ELMO. That's like a space age ELMO. Oh my God. I'm going to have to add this into my ELMO stuff that I do. Look at that high-tech ELMO. Oh my God. I wouldn't have even noticed it. I wouldn't have even known it was an ELMO were it not for the fact that I can tell he's putting stuff on a projector, because it doesn't look anything like the other ELMOs. Wow.
we come to the first
Go ELMO.
section
Go
of
ELMO.
justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful, if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because George Torres was zipped up in that suitcase.
Yeah, I
He
agree.
couldn't commit or
I
attempt to
agree.
commit a murder on anybody.
Nice.
He couldn't even scratch his own head while he
Yeah.
was in that suitcase.
And in fact, I pointed out that it sounds like they did find a phone in that suitcase, and it was his phone. And so he also couldn't move enough to get that phone and call for help either.
Next, we turn to excusable homicide. Here we have several paragraphs. And it reads, the killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident and in misfortune, doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent. Well, the problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when George Torres was in here, he was laughing and giggling and they were joking.
The other thing I will note, and I'll back it up a second, what I think is great about this is that, you know, I've always said I'm a fan of reading the jury instructions before closing arguments. That's usually the practice. An exception to that, guess who? Judge Bev, right? Read the jury instructions after closing arguments. So a lot of people were saying, you know, wait, hold on. Didn't she? I'm pretty sure she did. I'm pretty sure she did. Because the attorney, right, she did, because the defense asked her to read it before and she said, no, I'll read it after. And I know a lot of people were saying, you know, that one complaint that they had with both sides was that neither of them were referring to the jury instructions. But, you know, I kept thinking to myself, well, the jury doesn't know the jury instructions yet, so there's nothing to refer to. So anyway, I think it's better to, you know, have the jury instructions ahead of time. It matters. And this is a perfect example. And so not only is Mr. Cacciatore using the actual jury instructions, the physical paper on the ELMO here and going through it, he's doing this right off the bat, right after the jury heard it. So what he's doing is like the jury just heard these from the judge, right? Now he's like, all right, let's go through it again. And now I'm going to show you exactly how this applies or doesn't apply to this case specifically while it's still fresh in their mind. So I think it's brilliant.
Her testimony was that when George Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said she
Pointing.
wanted him to stay in there
I love that.
so he could feel uncomfortable. So he could feel her grievances.
You can squirm.
Ladies and gentlemen, that is not lawful.
Nope.
That is not the use of ordinary caution. And that is not
I mean,
applicable in this circumstance.
I will say he would have been justified, in my opinion, to use force against her in this situation. Like the only person who was justified with the circumstances where she's trying to punish him, she's retaliating, she's putting him in like he would have been justified in using force against her, you know. So
Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. George Torres couldn't provoke anything from his circumstance. George Torres was confined to this box.
Yeah.
Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used, and the killing is not done in a cruel and unusual manner. This fails on 2 counts. There was no sudden combat. Her words, this was laughing and joking, and we're all having fun, when she decides that it's going to get a little extra real for George Torres. And it fails on the 2nd count because George Torres was killed in a cruel and unusual manner. Next, we turn to our main charge, 2nd-degree murder. The law informs us that to prove the crime of 2nd-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of 2nd-degree murder to be for the defendant to be found guilty in this case. We've been hearing all kinds of facts for almost 2 weeks now of trial, but these are the 3 facts that had to have been met by the reasonable doubt standard in order to be found guilty. Ladies and gentlemen, I submit to you that the state has proven 2nd-degree murder beyond all doubt. And the proof of that guilt is overwhelming. But I will cite for each element just one fact that conclusively proves each of those elements beyond all doubt.
Now notice he's saying he just said it a second time. I was going to pause it and I was waiting for him to finish his sentence, but he said it a second time. He is saying beyond all doubt. Wow. He's not even saying beyond a reasonable doubt. He's saying beyond all doubt. And I don't know that I've ever heard any prosecutor do that. That is bold. I mean, I would agree with him, but that is bold. He's saying beyond all doubt. It really stands out because you're so used to hearing beyond a reasonable doubt. And in fact, oftentimes prosecutors will, in their closing arguments, they will make the argument, remember, ladies and gentlemen, we don't have to prove it beyond all doubt, just a reasonable doubt, right? And they will emphasize that, which is legally correct. He's like, fuck that. We proved it beyond all doubt. Do it.
As to the first fact, that George Torres is dead, well, we have stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up.
Here's the handwriting.
Zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. It's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or a series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays a difference in human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you. ING 1062.
Oh boy.
States 17. Mr. J, may you publish States 17?
Okay. This is where they play the video and they have that instruction. Love that.
For everything you've done to me.
Shallow.
For everything you've done to me.
Shallow.
Fuck you.
Shallow.
Fuck you.
Shallow.
Stupid.
Shallow.
That's my name. Don't wear it out.
Shallow. I can't fucking breathe, babe. Seriously.
Yeah, that's when you do and you choke me.
Shallow.
And here's this. So then we lose the court for a second. This is where they're escorting, presumably that's George's mother, out of the courtroom. Yeah, there goes the family.
Shallow. Sarah, I can't breathe, babe.
That's on you.
Sarah, I can't breathe.
It's on you.
Sarah.
Real ransom. Now you want to give it for it extra. Because I got this.
Sarah.
Real ransom.
Sarah. Sarah, I can't breathe, babe.
Oh. That's finger me.
Sarah.
Fuck you.
Something, please, Sarah.
Yeah. You should probably shut the fuck up.
Sarah.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions.
Dude, I love the pointing at her like that. So good.
We know from the evidence that this was not the first time she had considered killing George Torres. We
Look at
know
that cute Elmo.
from the evidence that on January 13th, 2020, approximately 1 month prior
Yeah, I
to
mean,
George Torres's murder,
this is not their strongest argument because that could mean other things. When you've got so much other strong evidence, I just don't know that this is all that helpful. I mean, you know,
the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. Bless you and all of you too. I'll get rid of him. Then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary
there it is
for the
again.
state to prove the defendant had an intent to cause death.
Yep. Despite how much
Yes.
Sarah wished that was the case. Not intentional. Not malicious.
I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder. in this
Yes,
case.
sir. Do
Turning
it.
our attention towards voluntary intoxication. If there was any question
He's like,
about the
he's like,
fact
I'm
that
not going to waste my time with that nonsense.
Sarah imbibed alcohol on the night that George Torres was murdered, and that maybe somehow that would excuse the conduct, there would be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retrieve. Ladies and gentlemen, in a few moments, Mr. Owens will rise, and he's going to show you this.
I love this. So dismissive. I love it.
And this.
So dismissive. It's great.
And this.
Dude.
And he's going to talk, and this as well, about the list of grievances that Sarah Boone had for George Torres. He's going to talk to you about curtain rods.
Just chucks it in the pile.
He's going to talk to you about black eyes.
Yeah, I mean, dude.
He's going to talk to you about what an awful, awful boyfriend George Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact
Yes,
that
sir.
the defendant is not entitled to the justifiable use of deadly force.
Very good.
Because as we continue to read this instruction, it tells us in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it, hide and go seek time. George gets into the suitcase. She comes and zips him up. But we're still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, George Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger, other than using deadly force on George Torres. He couldn't exert anything, ladies and gentlemen. George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his Judge Object?
Approach.
So I think this was an objection to invading the province of the jury here.
This is no help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, George Torres never got a chance to do anything.
Yeah.
George Torres never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable.
Where he crosses it off.
And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us, again, you find that Sarah Boone, because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now, we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the special instruction on battered spouse. You have heard evidence that Sarah Boone suffered from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we've heard from 3 experts in the areas of battered spouse in this case. I think at the outset, it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that George Torres, at points, mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean that because he did these awful bad things, that now through the rest of time, she's a battered spouse and she just has the right to kill him or to make him suffer or to punish him or to make him feel uncomfortable or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does, it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brandon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brandon's testimony that was very critical. Dr. Brandon talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brandon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony, because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. In her opinion, was much more straightforward. Remember, Dr. Brannon did not render an opinion as to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brannon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on meant that the trigger was not domestic violence or some threat. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's a reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because George Torres never got out of that box. He never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
I'm gonna go to court and I'm gonna tell the judge, listen, my fiance has nothing to do with it. It's all my fault. We were both taking it out of hands. Isolated situation that has never happened before. I love my fiance. She's a good woman. Her being in trouble in her life, she has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys have to train us to be.
She
Especially her. So please, if you can,
dismiss
dismiss this case.
Closed.
Drop it. She is not the type of person.
good person,
She's a great person.
angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. I love you to death. And I hate that we're going through this.
Sonnet,
What?
and it did.
I love you to death.
Whatever you understand. God will prevail and he will take us out of this situation. Love you.
God will prevail and he will take us out of this situation. I love you. Like foreshadowing.
Clearly, George Torres is dominating the defendant. Clearly,
Right.
George Torres is the one telling the defendant what to do. Clearly, George Torres is the one calling the shots at 4748 France Lane. Ladies and gentlemen, Are we so sure that George Torres wasn't the person suffering from battered spouse syndrome?
I mean, that's saying what we're all thinking.
Next, we're going to come to the justifiable use of non-deadly force. The language and the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed that the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. George Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah and Jorge, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took, torturing George Torres, to her follow-up video at 11:23, after she had moved the suitcase. Mr. J, we published from States 17, IMG 1063.
Sarah,
It was a short video. Well, what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later, from the time that started, you see that the makeshift coffin that he's in has been moved, and his voice now is softer.
How powerful is that, though, the makeshift coffin? I mean, yes.
The life is draining from George Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes
Look at
that
him.
was not recorded. There was only George Torres in this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said.
I'm going to jump ahead a little bit because I want to make sure we have time to get to Mr.
Ms.
Owens.
Guilt. When she described using that baseball bat to hit George Torres's fingers back in the suitcase when he attempted to save his life. Do you have any doubt when she is given how many versions of events in
Yeah,
this case?
I know, right?
Do you have any doubt after hearing the testimony of her neighbors about the loud crash and arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich?
I don't.
Do you have any doubt after watching the videos of George Torres being murdered and her laughing about it and talking about the fact that he cheated on her? Do you have any doubt after reading the text messages from her phone, after seeing the videos of how she controlled and manipulated George Torres? And if you say, Mr. Cacciatore, I still have a doubt, well, then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone.
Yes,
It
sir.
is not a reasonable doubt. But if you find yourself back in that deliberation room, and you are just trying to think of some way in which the defendant is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
Members of the jury, it is 4:04. As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. You do not have any discussions among yourselves or anyone else. We'll bring you back in about 15 minutes. Thank you very much.
Okay, so now they're going to have that discussion about the disruption and Owens moves for mistrial and stuff. I just wanted to summarize a couple things, my thoughts on this prosecution closing. As far as prosecution closing arguments go, what comes to mind when I think of my favorite would be Creighton, Waters, right? And then this one. Very, very, very different styles, but this was a great closing argument from the state. It was very methodical. It was very linear, easy to follow. It was very clear. It was very prepared. You could tell it was well prepared. It was well thought out. It went through. I love the use of the jury instructions throughout the entire time. I know it was a great closing argument. So yeah, that's definitely one that will stick with me in terms of closing arguments from the state. I'm not gonna play all this business with the disruption. I just it's offensive, and you guys have probably seen it. I'm gonna go ahead to Owens's close. So now for something completely different. Her hair. Her hair has seen better days, even though that's a low bar. Why is she smiling, dude?
State, you recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury. Thank you. You all may be seated. Members of the jury, for one of the last times, if you could, please raise your hands to confirm that you complied with the court's instructions. All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir.
Oh,
Yes, sir. Thank you.
buckle up, guys.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson, and the girls, we're all from Milton. I think y'all figured that out, but we were from out of town, Santa Rosa County, Northwest Florida.
Hang on, let's watch this part again.
Sir, thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson, and the girls, we're all from Milton. I think y'all figured that out, but we were from out of town, Santa Rosa County, it's Northwest Florida, close to Pensacola.
Cares.
And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico.
Oh, I need an objection.
The team, the defense team, is here.
What was
And,
that
they're here
gesture?
to represent with Sarah Boone. And we feel confident that I'm going to be able to show you why she's not guilty. Okay? Now, I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that I'm going to show you. And then we got a couple of videos at the end. Okay? And we're going to try our best to help you make the right decision. Okay?
So he's already in the first like 30 seconds, he's been like, yeah, I'm like kind of disorganized here, but we're going to try our best. Like what? What is happening? Remember what I said earlier about how he had asked if they could split the defense close. And then remember the whole thing about the timing. So that whole business in between the state and the defense closing where they, went off the record and then came back on the record. And remember, they're way off schedule now. I remember at the time thinking that he started his closing argument around 4:00. And remember, the plan initially was that they were going to be all done by 5, and the jury would be handed the case at that point. But now, again, I think it was, or maybe it might have still been that the state was still going at 4:00. I remember at 4:00, I was like thinking, what are they going to do? Because they can't postpone the other closing till Monday, right? So just keep that in mind.
But yeah, Milton's a small town.
Objection.
Overruled.
See how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. Very small town. We didn't know what to expect coming down here to Orlando.
Oh my God.
Judge, I'm allowed to.
I'll give you a little bit more for intro, then we need to get into it.
Have you never been to
I'm
Orlando?
going to get into it. I wanted to say.
Dear
It's
God.
a small town, good people. We've been down here 3 weeks.
And this is when I was like, oh my God, he's filibustering. He's filibustering. That is what he's doing. Because it started earlier in the day when they tried to say, can we have 2 closes with him and Mr. Henderson? And I, whatever, that I've heard that before, but it became really clear. And then taking all that time up, right? And right before he started, and now all this. And I was like, oh my God, he's filibustering, because this is what I think. So remember, they're behind schedule. There was already talk, and they'd already discussed with the jury that they can stay as late as they want. It's going to be kind of up to them. So my thought is that he was thinking that if he could take for fucking ever with the longest close ever, and then it's so late by the time the state starts their rebuttal close, and then the jury's hungry and they go have their dinner, if it's just so late by then that the jury will either start deliberating and then say, we are exhausted, we've been here for 12 hours, we want to go home and come back on Monday, or that they would just say, they would eat their dinner and then go home, right? Because usually, as you guys may know, it is beneficial, right? A quick verdict is usually not good for the defense. And with such a strong closing argument from the state, you better believe that Owens would rather them have time over the weekend to forget some of that, right? And come back without all of those arguments fresh in their mind, without having just gone through the jury instructions from with the prosecutor and everything he laid out so clearly. And so I think he's trying to filibuster here to push it back because it's already so late. They're already behind, make it as late as possible. And, I realized they did the same thing in the Ezra trial where it was a similar situation. The jury wasn't handed the case for deliberation until like 7 or 8 o'clock or something like that, crazy. And it was also up to them. They could have either stayed or they could have come back, and they wanted to stay. But Mr. Nelson's closing argument was like triple the length of the state, maybe even more so. It was crazy. And it was really repetitive and redundant. And he was like super unhinged. And he was also very disorganized. And that's what made me think of it too, was like the disorganization, you're trying to find this, you're shuffling around, all that is kind of wasting time. That's not a great strategy if you're trying to give a good closing argument. However, if you're the defense attorney and you think, yeah, we're going to lose, then perhaps the strategy here isn't to give a great closing argument. Perhaps the strategy is to give a terrible closing argument that takes a long time so that the jury comes back to deliberate after the weekend. I think that's what we're seeing here.
We didn't know what to expect. We've been surprised.
Objection. Improper argument.
Mr. Owens, approach.
Third objection. Oh yeah, it just gets worse. It just goes downhill the entire time. It's so bad and so disorganized and so irrelevant that, and the thing is it's like, and so long. Same thing with Mr. Nelson's. They were both really, really, really long closing arguments. Mr. Nelson's might have actually been longer, but at least he was relevant, although he did repeat himself a lot. But this is a really clear like with Mr. Nelson, it wasn't so obvious that he was filibustering. He seemed unwell, and that was maybe the cause of his disorganization. This, to me, is more obvious filibustering. So
It's just, since we've been here, we've been treated with respect and hospitality.
like, what is this?
And just like we've been at home. We appreciate that.
Oh, for fuck's sake.
Now, I'm going to do some reading, and then I'm going to do some talking.
Oh boy. Oh boy.
Ultimately, this is about justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us
Protect us from defending ourselves?
from potential attack. And
Ooh.
you are the only ones, in this case, because Sarah Boone was arrested, that's going to be able to look at it critically and objectively. Objectively. I like the state attorney.
Objection.
Oh, yeah,
Overruled.
Objectively.
I think it
And the law in Florida gives you all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial and some of the things they said.
Objection. Objection. Remove motion.
Yes.
Okay, we're on our fifth objection. He's just getting started. There's one of quote unquote the girls talking to Sarah. Shout out to the girl.
Thank you. They got their side, their position, we've got our side. So we're going to talk about that. But, and we're going to talk about justifiable use of deadly force and non-deadly force. But either way, however you rule, it still justifies her behavior.
What?
And the result is nothing. Now, I don't believe there's anybody that
Objection. Proper argument.
Overruled.
Objection to approach.
Yes.
Oh, y'all, look at what he just did. Hold on. Do you see him? He's like praying.
Yes.
Hold on. Watch.
I don't believe there's anybody that
Objection. Proper argument.
Overruled.
Objection to approach.
Yes.
I've never, ever seen this many objections so in such rapid succession in a closing argument. There were a lot of objections to Mr. Nelson's closing argument in the Ezra trial, but they weren't as quick in succession as this. This is insane. I mean, they're mostly warranted, I would say, but again, think about it, right? Remember, every time Mr. Owens does something that's objection, like he could be doing this on purpose in a way, right? Because every time he says something that's objectionable and they object and then they ask to approach, guess what it does? It buys more time, or it eats up more time, right? It eats up more time. It eats up more time. Every one of these already, they've probably spent more time approached, and I'm fast forwarding it, right? Approached than he's even done talking. So again, I think the strategy here is not to present a good closing argument. I think the strategy is to delay.
I think you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is George Torres. The reason for the trauma is George Torres. From the positive things about the man that we've seen on video to the positive things Sarah Boone has testified about, to the violent monster he becomes. And I mean monster, because it was repeatedly.
Hey, monster.
And what happens the next day? Man, I don't remember. I was drunk.
No.
I don't remember.
No, the next day is I don't remember. I wasn't drunk. I don't drink. I can't drink. I'm unable to drink. That's what was happening. Up until like this trial.
That's the gaslighting.
Actually, well, sorry, I take it back. Finally, like towards the end of the interrogation, she did switch to from like I don't drink, I can't drink, to like maybe I had one glass of wine, to like I blame it on the alcohol. Like verbatim, she said that. So.
That this young woman, vulnerable woman with nobody,
Wait, young woman, wasn't she in her? She was in her 40s. Okay.
just starving for love, starving for attention, and seeing the good in the man. And it was good. But every day was on the balance. She measured every day, depending on how it started and then how it ended. And that's the way she had to live her life, day in and day out, day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony.
Oh God, no.
But she spoke about some of the veterans that had been in the war.
So he's now comparing Sarah Boone to a veteran? Is that what is happening now? That's what it looks like is happening now.
You know, and people in war,
Oh God.
a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people,
Filibustering, the history of PTSD as it relates to like Vietnam vets. Like that's what's happening now.
in wartime,
No,
were police officers.
no.
Police officers.
Oh,
that get
God.
post-traumatic stress. And a lot of them come in, the males come in with this bravado, I'm all right. I'm all right.
Objection relevance.
That's why Dr. Harper was talking about the veterans. That's what they'll do. But you've got to spend time with them. You just can't be one session. And you've got to run post-traumatic stress testing, which tells whether they really have post-traumatic stress. And we all probably have experienced some trauma. All of us have lost some loved ones. And it's awful. You're in shock. You can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time, right? Time heals.
What is he talking
Right.
about? What is he talking about?
These veterans that come back from a deployment, they get back. They get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals.
No, that's misstating the
Everybody, it
testimony.
helps. Just time.
Oh my God.
Overcoming a divorce.
I mean,
Overcoming
there
a
you
death,
go.
Whatever trauma.
That's him right there. I think it's like a Freudian slip. Like, look at how many times he's talking about time. Yes, you're trying to kill time. You're trying to waste time. Listen.
Time heals. Everybody, it helps. Just time. Overcoming a divorce, overcoming a death, whatever trauma. Sarah Boone had no break. No break. Learned helplessness. Just giving up. Just giving up. I can't get out of this situation. They broke up. She go about 2 days. Jackson and Colin just learned helplessness. And it's, in the manual. Battered spouse syndrome is not, but what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind. And it's repeating itself. It's repeating itself again and again, day in and day out.
You're repeating yourself just like Owens.
And when you look at this law, that's what you have to apply. Someone in Sarah Boone's shoes, when you're deciding whether her conduct was reasonable. Got a bunch of notes.
Oh, boy. There we go.
Something I wanted to read.
Now, one of my favorite things is that happens a couple times during his closing where he says, I'm going to try to find this thing. It take a while to find this thing because it's really important. I want to make sure I get it right. It takes a long time. And then he never finds it. And then he just paraphrases. It's great. It's really excellent stuff. Fantastic. Oh, boy.
Where'd that put?
Where did I put that? This is a lot like what Nelson did in the Ezra trial.
Sarah Boone's long-term exposure to abuse created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind. George Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute Suitcase video, is a trauma response. Sarah Boone acted out of a sense of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse. And I'm going to ask you to try to understand. Try to understand. Sarah Boone being emotionally and psychologically broken, whose actions may have been misguided attempts at survival but not murder. Imminent danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Brandon, you remember him. He was the first expert on trauma.
Great. So most of what he said, I thought was
Put some notes.
great.
Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think.
Oh my God.
He talked about the trauma, that you cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to you. It changes your behavior, not only your behavior, but your thinking, your subjective thinking about fear and
That pose.
And if you remember, Dr. Brandon said it's all about that person's perception. Okay, a lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time.
But she has said time and time again that when he drinks, it's bad. She gets abused. Sure, there has never been any testimony that when either of them are drinking, I guess usually she's talking about him drinking, but there's never been any testimony that when he's drinking, they have a good time. She said, we had a great day, blah, blah, right, in the day of, but that's like when they only had that half bottle or whatever, right? And it was like, once there was more alcohol, then, it changed. So remember, and like when they went through all those pictures of the alleged DV incidents, they tried to connect every single one of those to alcohol, like that he was drinking. So anyway, it just doesn't make
He
sense.
falls asleep, passes out, he falls asleep, passes. But it may turn, depending on his mood. I don't know if you can tell, she would try to placate him.
I couldn't tell.
Dr. Brandon said, when you're trying to evaluate somebody, it takes time to get them to trust you.
You already
And
said that.
the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in an abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at. What a reasonable person would do under their perception of danger. Now, we'll go on. Trauma experts explain how victims' reactions in moments of stress are the product of the damaged psyche. Her actions, although tragic, and it was a tragedy, George Torres lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect. Sarah Boone with argue with him, talk down to him. Some would say, well, someone.
You know what's funny is I bet that really bothered her that he said that.
Sarah's not charged with that. Sarah Boone is not charged with that. And I want to read you something
Oh boy.
on that subject. Essentially,
Oh my god. Oh my god. Look at all those tabs. Oh
I
dear.
don't know what it's at.
Oh
I'm
god.
going to have to come back to it. But essentially what it said was, was
Wow.
eventually,
Oh my god. Dude. What is happening? Is he gonna find it?
it's been a 2-week trial, I want you to know. I'm trying to get this right. I know it's important. What I wanted to say was someone can be mean and angry and hateful, intoxicated, and still be abused. They're not mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has committed verbal abuse, it is important to remember that they, Sarah Boone, are the
What is
victim
he reading?
and have been pulled into an extremely vicious cycle where they are trying to survive. Sarah Boone intentionally left George Torres in the suitcase.
What is he reading?
What's the act of a battered spouse syndrome woman? She went up to her room, she fell asleep, and passed out. These actions are disconnected. Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do. That's real fear, that's real trauma that she was experiencing at that time. Now, I talked to you about force being used. And I think I talked to you about blocking an attack and using a physical restraint like the suitcase to block somebody's attack.
Oh my god.
And the example I give, I've got a couple of examples that may or may not apply. Let's say you're in a bar.
Oh no. See? We don't need an example. But if you're gonna give one example, but I got what do you say? Several examples, a lot of examples. Oh boy.
You got your buddies and the other guy's got their buddies and they're drinking and it ends up being an argument between two of them.
I guess they're
You
gonna
realize these two are fixing to get in it. Well, one of your buddies comes around on the other side and grabs the guy before he's able to strike him, right?
act
So
it
you're
out.
committing an offense on this guy, but it's a restraint. It's a restraint. You grab him by the neck
Oh my god.
and try to get him out the bar. So yeah, you're committing an act, but it's designed to defend another, which is legal. Or let's
Send another person.
say you have a situation where you have a police officer and he's on patrol. You know, he's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he's called, he goes to a call where there's a suspect that may be armed. A suspect that may be armed. And so he gets there, he gets out of the squad car, he's walking around, of course he's taking out his gun because he realizes he may be armed. And eventually he sees the suspect and the suspect reaches for his waist. Now, in that moment in time, that officer has to make a decision. Am I going home with my family tonight?
What? How does this apply?
And I asked
Oh my god.
Warner about this Vaseline thing, he's called fear response or fight or flight. You know, those decisions are made, it's instinctive. Based on your set of circumstances, she instinctively reacted to her unique set of circumstances to save her life
Oh my
or
god.
save herself from another one of these. I'm 63.
What is happening?
I can't imagine that.
What? He should have at least picked up one of the pictures that maybe could count as great bodily harm. And I would say probably the only thing that would count is the knife wound. I know Candace says, why would he use a cop example? Ridiculous. So first it was the Vietnam vet example, or just maybe he wasn't that specific. He was just talking about veterans. And now it's cops. What?
I can't imagine that. Her father's not around.
He's trying to act like he's even said it. He's even said this young woman, Like she's in her 40s. Like I think at this point her late 40s. Honestly, he's not that much older than she is. You're trying to act like she's like a helpless child. Like anyway.
I didn't talk about the case.
Oh dear.
If you remember, I'll get back.
Oh my God! No,
If
don't.
you
Don't.
remember, that's what was it.
Oh no. Hold on, string.
Let's start with the witnesses, and then I'll talk about Sarah. But the first witness out of the box for the state, if you remember, was Juan Torres, the brother. Remember that? It was some time ago. It's been a while. Y'all taking notes. You may have to go back. Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us.
How?
Remember Tony Henderson with the cross-examiner, Juan Torres.
Oh, I know where he's going with this.
Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me. Mr. Henderson said, did that surprise you? Juan Torres said no.
I hate that the state didn't come up on redirect and say, why didn't it surprise you? I remember thinking he kind of asked it, but it wasn't open-ended like that. Or maybe he didn't ask at all. It was really disappointing. You know, I mean, in the end, it wasn't necessary because it became clear with all the body cam footage and stuff that, you know, this was a pattern that she had of feigning. You know, it's always like this, right? The projecting, right? Because like in her interrogation, when she says that George was the boy who cried wolf, well, you know, again, that's what we saw. The evidence bore out that she was the one, of course, right? You know, anyway, so when he said it didn't surprise him, it's because she has done this before, and not that it was something that was happening, I think.
That family knew what was going on. The police knew what was going on. The neighbors knew what was going on. Colonel Walker came in here, 80-something years old, in a wheelchair. Kevin Beck called her up. She saw it. Is there any doubt? Is there any doubt? I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Owens. She suffers from Battered syndrome. But if they don't direct, well, maybe I don't really know. I hadn't had enough time to really see her. You hadn't seen the pictures? You hadn't seen the 2-minute video? You've seen her one time earlier this month. One time. And she's going to start testifying about stuff she's never said before until she showed up in court. About, well, based on what she told me, I don't think she was in imminent fear. Come on. This is a courtroom. This is courtroom. Good thing y'all are here. Well, thank you. But it gets even worse than that. It gets even worse than that here in this courtroom. The state attorney referred to these pictures. And I was going to rise up and show these pictures to you.
Overruled. You may proceed.
And I was going to rise up and show these pictures to you. Well, yeah, I'm going to do that. They put her on trial for murder. But what did they say? And I got to turn to this. Make sure I get this exactly like they said it.
Oh boy.
I took a bunch of notes.
We know. Maybe you should have taken less
I got
notes,
this quote.
and then you could find things.
Can't even find it. It was something to the effect, maybe George Torres is the battered spouse. Can you believe it? Can you believe that?
Yes, I do believe it.
Now you know why we're here.
No.
Now you know why we're here. Little boys learn early on.
Oh
that
no.
Girls are different.
Oh God.
You do not put your hands on a girl. You can't wrestle with them. You can't punch them. You can't kick them. You can't treat women that way. when you become adults, I don't care what she does to you. I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman. No, sir.
What? I don't understand.
What has the state attorney tried to do?
Objection, upper argument.
Sustained.
What has they done?
Being a
What evidence that they tried to put on?
Overruled.
What evidence that they tried to paint Sarah as? What evidence? Controlled and manipulated were the words they used. You know, this ain't the 1900s. This is 2024.
Well, could have fooled me.
What's all these text messages?
Here.
What is that?
He's like, little boys are taught blah, 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 blah. Never hit a blah, blah, blah. And then he's like, this isn't 1920s. This is 2024. I'm like, sir,
Relevant.
it's you.
What are they trying to claim? She provoked his violence? She provoked his violence.
No, he wasn't violent. That's the thing.
Isn't that what they've done here in this trial?
Upper argument.
Sustained.
Let me get back on this.
Oh, God.
Abraham Marino. I don't know if you remember him. Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there.
I don't know. He always, this is like a thing he keeps doing. He's saying, I don't know if you remember. I don't know what that's about, because it's like, if they don't remember, then what you're going to say is irrelevant. And you should, it doesn't make any sense. It's like, and they might not know if they remember until you start talking about it. And then they be like, oh yeah, I do remember. Right. It's just like, he's like, I don't know if you remember. And it's like, before he's even, they don't even know what the premise is yet. It's just weird.
And some neighbors were coming around, there were 2 or 3 neighbors sitting around. He said, Sarah came out and stated it was an accident. Okay. Well, then, it was an accident. Abraham Marino knew George Torres from Philly. Okay. They were friends. They would talk either at the complex, or if Marino went to Holiday's Hardware or Ace Hardware, what it's called. The state attorney notifies.
Good. I'm going to object to reading from things that not in evidence.
Approach.
So he just got his cell phone. I don't know. You can't, I've never seen that in a closing argument where they just go get their cell phone and start reading from it. Special and unique to him. Incredible, really. Wow.
That's all I heard Sarah say that afternoon was it was an accident. Then he came in here today, or this week, and said, no, she said, I was teaching him a lesson, things got out of hand, and then I fell asleep. 4.5 years later, we know he's friends with Torres. You heard it here.
No, we're not
I
friends.
want to talk to you
That's not
about
what we heard.
the 2 boys that live right next door. You remember Vincent Battaglia and Brandon Motes? Remember those guys? And you remember it came out in testimony, this event happened on February 23rd of 2020. But it came out in testimony that Sarah had said, George Torres, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs in my apartment from top to bottom, which is consistent with what they were saying happened, remember? But they got the dates wrong. And remember, Mr. Henderson called Deputy Copsel, or Detective Copsel up in our case, and she had to say, yeah, I didn't take their 2 statements until the 27th, February the 27th, remember? So they're remembering back, and they both had similar stories. Of course, they had time to talk by then on the 27th. I think the only recorded interviews they got that the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone, right? So they came back following up on the 27th. That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound. You remember Sarah testifying? No, that was the night before. I complained about that. And I think one of them had testified. Yes, she had said something about being drugged down the night before. It may have been, can't remember now who it was. One of them. And, it looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think We didn't have anything for that, remember? And then this photograph, which we introduced, which shows the bottom of the stairs, as you can see, there's Lucas's bookshelf, right? This is where Sarah Boone stored Lucas's stuff. And you can see it's not disturbed at all. Anyway, I want to get back to Sarah. I want to talk a little bit about that. But let me talk a little bit about the law on justifiable use of force. Is legal and lawful if you reasonably believe, I probably already understand it by now, you reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations. By acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. If you're facing, in your mind, a reasonable imminent threat, you don't have to wait. Let's talk about Sarah Boone and this unconventional form of physical restraint to block the attack of George Torres. What did she say? You saw something. Now, you got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking. And you got to think about the fact that it was all fun and games for a while. And I think the biggest thing to know is that George Torres chose to get into this. He's a grown man. That was his choice. She didn't force him in at gunpoint to get into that suitcase. He voluntarily got into that
That is not
suitcase because
her
they were drunk and being silly and stupid
relevant.
and playing hide and seek. Which I guess when you
Act
get so drunk,
with the
that's what you
zipping and but not unzipping.
zipped him up, they're laughing, carrying on. And as you know, Sarah likes to videotape a lot. And I know you've seen some of these videos and you're wondering
Why?
but I think the evidence
Why would you draw attention to the videos?
shows that when
Oh, God.
George is being videotaped, he's not going to do anything. If you think about that, when George is being videotaped, that's like her power. Dr. Harper said that Sarah's words are her power. Sarah's words are her power. Physically, she's no match for him. Physically, she's no match. But that's her power, so knows. When she gets a chance, to have some control, that's what she does. And she videotapes, but she knows when she's videotaping, she can tell it like it is.
Here's the problem with this. George was in a suitcase and he did not know she was videoing him. This is so silly. That while in a different world, I can imagine this would make sense, right? If you were videotaping, like that would make sense, right? However, even if you could say that this was true for all the other videos that she took, the suitcase video, he did not know she was videoing. So to say that she was videoing and to use that as almost like a threat or a way to, because it's like, oh, he's not going to do something dangerous as long as he's videoing. He didn't know she was videoing. And, what was my second point about this? I'll think of it. I had another point too, but I think that's the key thing is he did not know. The other times, sure, he knew he was being videoed, but he did not know it when he was in the suitcase. So
I can tell him what I want to tell him. A couple of these videos you've seen, she's telling him what to do. But she's got that video camera on and George knows. He's being videoed.
not in the
We got
suitcase.
one, we're going to show you a little bit. Before he loses it. Just a little bit. Right there. And then, of course, we got the TV. But they're kidding around, playing around. Then Sarah realizes, okay, this is my chance to say something to him. So she sits down, she turns on the phone, and you've seen the tape. You've seen the tape.
Are you going to play it? No way. Don't do that. Why would you do that? Don't play it.
For everything you've done to me.
Oh,
On the first words out of Sarah's mouth when the video
Right.
began.
Okay, just as bad as playing the tapes. Because that, okay. For everything you've done to me, obviously, as the jury knows, they just have the instructions, is literally not the definition of self-defense. It's the opposite. It's literally like, what are you doing? Ugh.
There's a lot packed into those words. Think about that. For everything you've done to me.
Yeah, there is. It's a retaliation. Punishment.
This is how it feels when you choke me. Now that's in direct response to the result of the abuse that she suffered at the hands of George Boone. She wants him for that moment to feel how she feels. For him to feel how she feels. uncomfortable, lack of control that she feels when George is violent with her. Just for a moment, she won't be able to do that. And if you can imagine,
Approach.
Oh, right, that's improper argument. That's why there was an objection there.
I think from the evidence, you can determine she was crazy. She was crazy.
She's crazy about him?
You know, of course, it's a syndrome,
What? She was crazy about him?
but she felt like she couldn't do it out. And let's say she videotapes it, and then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9. I think you count 2 of the other minutes. But there's 9 minutes that we don't have video. But what did Sarah say? Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe. She had said she had some anger. And of course, she doesn't realize the situation, that it's going to end the way it ends. So she has no appreciation of that. It's a canvas. It's all she knows, an old canvas suitcase. And she's got some, the 2 zippers removed or spread out a little bit. So she thinks he's not being serious. But eventually he gets angry. She gets angry, he gets angry. He says words to her, and then his hand starts to come out of the suitcase. She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend, girlfriend, but you know what I'm talking about. We've got a way of talking to people. We've got a way, your wife, your husband, you know each other. You know, when they come in from work, what kind of mood they're in. Just by a couple of things, the way you can just sense it, right? Well, especially somebody as hypervigilant as Sarah, and as hypervigilant as a battered spouse woman would realize that he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out. At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in. Remember? She tried to get his hand to go back in. Wouldn't go back in. So her son's back was 3 feet away. Where the police found it the next morning. Same spot. No attempts to hide. No attempts to delete phone. No attempts to tamper with evidence. Nothing. In the same spot as it was. She picks up the bat. She pokes. She pokes him hard, trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries. And you saw some of the circular injuries where you can tell there's a poking. I think it's right around here. She
Poking?
poked him several times. Remember the pathologist said, I think, maybe 5, 6, or 7 times. She pokes him. And he's got some scratches. I don't know if they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside the lining. There's some lining, and it's for support when you walk in.
He just said the metal bars are inside a lining. There's lining over the metal bars. So then how would he get scratches if there's a fabric? We all know what that's like. Those metal bars, yeah, there's a lining over it. How would he get scratches? Now, if the lining was not there, sure, okay, maybe. If there was a sharp edge or something. But we've seen the inside of that suitcase. They showed the jury the inside of that suitcase. The lining was intact. There was nothing poking out.
She testified. You heard what
Why would you ever want to remind the jury about that?
that she was justified. That's uncontroverted testimony.
Well,
Now-
actually,
Let's talk about the jury instructions just for a minute. I want to talk about reasonable doubt for a minute. Yeah, can't find things, but
can't find a thing.
I've got one. I've got one.
Oh.
If you find it. If you're all looking. I think it's on page 15 and 22. We're going to talk about reasonable doubt in a minute, but if you look at those bottom 3 short paragraphs, it is the evidence introduced in this trial, and it alone that you're to look for the evidence, or look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence. Five reasonable doubts, 17 reasonable doubts, 25 reasonable doubts. You have to have one reasonable doubt. I'm trying to show you throughout the evidence. But each one of you can have a different reasonable doubt. Difference, but one reasonable doubt about the state's case, and your verdict is not guilty, according to law. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt. speculative doubt or imaginary or forced doubt. Such a doubt must not influence you to return a verdict for not guilty if you have an abiding conviction of guilt. And this is a deeply held belief. Reasonable doubt is the highest standard we recognize in litigation. Car wreck or something like that is preponderance of the evidence standard, 51%. You're entitled.
Nelson
Abiding
also
conviction.
briefly, well, Nelson actually to a lengthy extent touched on the different burdens of proof in completely irrelevant cases that were like, family law, civil, all this other stuff. I mean, anyway, the stacks of paper, at least he was brief about it, but funny, they both did that.
That's a deeply held belief that you must have if you're thinking about something.
Like the jury does not need to know
That's a level of certainty that
unless
you would have.
it's related to part.
That's what you gotta have as a jury. I've got to be certain of her guilt. If, on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do, there is not an abiding conviction of guilt, so I'm not certain. I'm not certain of the guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable. You understand that? You've got to be certain of guilt. That's the high standard we recognize. If you've got some evidence of guilt, so okay, there's some evidence for conviction, but it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt. And you've got the power and authority and the obligation under the law, if that's the way you feel, to vote that way. Later in the instruction, it goes on. It's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jury to decide that. A jury may believe or disbelieve any or all the part of the evidence of the testimony of any witness. I want to show you this before I begin. But Dr. Werner said, this is their expert again. He testified that.
What is he doing? He's just jumping around all over the place.
That woman's experiences affect.
Why is that
perception of
redacted?
those past experiences with George Torres. Those past experiences with George Torres. And there's a bunch. Affect their perception. Remember Dr. Michael Brandon talked about perception. And then it's danger. Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from George was because of George Torres. George Torres is responsible for her mental state because of the way he has violently treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase? She knows. The second video is playing. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her. She used the bat to get him to stop trying to get out of it. Why would she do that? Why would she do that? I know what he's going to do. I know what he's going to do to me. I know him like I know him more than he knows himself. I know what he's going to do to me. You don't have to wait. That was justifiable. Now, you got to understand this. She intentionally used the bat to defend herself. She intentionally didn't unzip it to defend herself. Both of those are lawful under our law. She went upstairs. The dogs were upstairs. At some point, she called her husband, her ex-husband, Brian Boone. We know that many times she testified, or somebody in court said, she would often
Oh
flee
God,
to her ex-husband's house. Sometimes.
he was on a better streak, and then dude.
That's what came out. I mean, Sarah or somebody. Sometimes she would flee, or sometimes she would flee to upstairs. One of those two. But the dogs were
Testified to that.
upstairs. She made a phone call. At some point, she fell asleep, passed out, fell asleep. We don't know. They had 2
Where
big bottles of wine. Right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? You remember that? Now, I don't know if we did a good job of this, but
Oh my God, I don't know if we
she
did.
got arrested. You remember the one time when she got the black eye? She got arrested.
I don't know if we did it, dude. I don't know if we did a good job of this. He says.
You remember that? Now, I don't know if we did a good job of this, but it came out that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And you remember that? It was, they ended up over there by the dryer, and he was banging her back of her head on the floor that had very little carpet on it. And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her.
I love that he
And
got.
that's when he got up and stomped her in the eye. Remember? Well, the police came for that event, and they took statement, and Sarah was honest with the officers about, well, and they arrested her. You remember? Remember that? They arrested her. And she said, why? I was fighting back. You remember that? Why? I was fighting back. So from that point on, she didn't trust law enforcement.
Fighting back was not self-defense
The
either.
video that they showed a while ago about George, that was about dropping the case, where she was defending herself and fighting back. I want to talk about this investigation by law enforcement. Now, she didn't know the law. She's not a lawyer. She gets up the next morning. Brian's calling. Sarah's got to pick up Lucas at 3. Brian's calling. Eventually she walks down. She's looking for George. Where's George? He's quiet down there. Then she looks in the bathroom. She looks out. He's smoking a cigarette. He's on the computer. She sees the suitcase. And you can imagine.
Objection, overruled.
Sustained.
She sees him in the suitcase. She panics. What does she do? What does she do? She tries to get her fiance out of the suitcase. They're engaged to be married. She's not trying to kill him. They're engaged to be married. She gets him out. She tries to do, he's purple. She tries her best to do CPR. She doesn't, you heard her, I didn't know what to do. I didn't call Brian. That's her safety valve. That's all she's got. Brian eventually says she's come over. She calls again in 2 minutes. I'm on the way. He gets there. You got to call 911. I told her before, call 911. She calls 911. She tries to do CPR again. Is she busy trying to hide evidence? She's busy trying to hide evidence. She's busy trying to hide the back. No, she's trying to save his life. If she can. So the police get there. She knows if she told them she fought back, she's going to be arrested. That's what happened before. What happened before? Like George said on the video, she'd never been arrested before. Before that time, she was charged with that with George. She lies. She lies. She's scared. She's scared. She doesn't know what to do. So she lies. She makes a decision to lie. She don't trust law enforcement. She doesn't know the law. She doesn't call a lawyer. She talked to Officer Rodriguez, was the first short black female came up here first, the first one that arrived again. Talks to her. There's a report statement there where she doesn't tell the whole story. She lies. And then the detectives eventually get there and get her in the squad car. You hear the audio. I think it was played. She lies again. Then the next day, she goes down to the sheriff's department. Now, if they would have told her, hey, man, I'm going to arrest you, and she gets a lawyer to go down there to make a statement, and the lawyer would advise her.
Objection, facts not evidence.
Sustained.
Move to strike.
Stricken. The jury will pay no mention or give any weight to that statement.
She's not a lawyer. She didn't have a lawyer present when she made this statement. She didn't know the law. She didn't know she was justified in defending herself the way she did in this dysfunctional, toxic, abusive relationship. I don't know if you remember, it was a 2-hour video, but it was some things she said, not intentional.
Again, irrelevant.
Actually, she wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What she was talking about was that George passed. Was that George died. That was not intentional. She thought he was fine in there. Would he sober up? We've learned from their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern. How many times do we see Sarah call the law? That's their pattern. Sarah told me, I didn't know, I think she said, I didn't know something like this could happen. I've never done it before. And Detective Lowen said, well, what did you expect was going to happen? I've got a daughter that she,
I feel an analogy.
18 or 19, and she got a grandmother's hand-me-down pickup truck. It was an older truck, but she didn't have it long, and she was gassing it up, but she didn't put any oil in it. Eventually, it burnt them up.
Oh, boy.
And you don't know what you don't know. I hadn't done a good job of explaining, hey, you got to put oil in it too. Sarah Boone didn't know
Completely different.
they keep it dying in it. It's an old beat up
He
canvas.
said he couldn't
suitcase
breathe.
that She left a gap in. And as naive as that sounds, she didn't appreciate the danger. I mean, is that the way you want to kill somebody? Is that the way you're going to do it? She had Lucas to take care of. I'm not going to go to prison doing it like this. No attempt to hide the crime. I think the evidence is clear. That's how this happened. I don't want to belabor the point. I do want to show you. Just quickly show you the ending. Sarah Boone got stabbed. Think about that. Stabbed with a steak knife in the leg. And she stayed with it. She stayed with it. Poked between the eyes with a curtain rod. Stalked in the eye. And who does that? The law empowers an individual to defend their life and safety when faced with a threat and to prevent an attack. That's what Sarah Boone did. That's what Sarah Boone did. I think it's important to understand Sarah had to be the parent a lot of times. It was her place. She had that $1,000 a month from the divorce settlement coming in. She had the car. She had the phone. She had the keys. She had to be the parent in a lot of ways. I want to talk a little bit about Dr. Harper. Do you remember? Dr. Harper is from Okaloosa County, which is up in the Panhandle, close to where we're from. And she's the doctor that treated Sarah from early on. When this happened in 2020, I think she first saw Sarah Boone shortly thereafter. And over the 4.5 years, saw her 9 times and did all the testing for post-traumatic stress before she has the experience from veterans. And she's testified that she's now just traveling around the state, testifying as a forensic psychologist. But she talked about how important it is to develop trust with the patient over a course of time. It's just going to take time when you have somebody suffering that kind of trauma and that kind of damaged psyche. It's going to take some time to get them where they can trust you and really tell you and talk to you and tell you what's going on with them. And she talked about, Sarah uses her words for power. I think her testimony, I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony was
Objection
credible.
is sustained.
I can't give my person. Okay. The evidence supports that her testimony was credible because of the time that she spent, because of the number of tests that she did. She diagnosed with post-traumatic stress disorder, alcohol use disorder, anxiety disorder, and battered spouse syndrome. Dr. Warner confirmed that. And Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert. So he hadn't treated Sarah. He was just testifying about the condition. He's been doing it a long time. He's an expert at it. And that's to advise you to try to understand what's going on. And as crazy as it sounds, in this syndrome, they try to protect the abuser. They're in love with them. They try to protect them. I don't know if you remember that there was a time where Sarah Boone had a conversation with one of the neighbors, and they were talking about something. She said, "Did you hear anything yet last night?" Remember, she said, "Shh."
Oh, my God.
Okay. both George and Sarah lied to the police. They lied to medical people. I don't know if it's shame, but it just comes with the syndrome that you stay trapped in it.
Well, that's interesting. So you said that they both lied to multiple people. It just comes with the syndrome. Is that him kind of acknowledging, I think accidentally, that George was potentially the battered one here?
I think another big, if you think about this, when Sarah gets beaten by George, she calls the police. When Sarah gets beaten by George, she calls the police. And a lot of times she just wants him out. Just get him out. Get him to leave. She doesn't want him to get in trouble. She just wants him out. There never was a report of George calling the police on Sarah. She wasn't physically abusing him. The state is trying to present evidence that she emotionally abused him.
Sustained.
Yeah.
Stricken. Members of the jury, pay no attention to that comment.
Wow.
Give no weight whatsoever.
I believe the evidence that's been presented by the state is an attempt to show that Sarah mentally or emotionally abused George Torrance. Again, she's not charged with that. She's not perfect. Some of that was her trauma. In Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some, But the homicide detectives, I don't know if you saw that 2-hour video. At some point in the 2-hour video, they started talking
know
about
you
some of
saw
the
it.
violence. And they go, we know.
Because I don't know if you saw that 2-hour video. You know they saw it.
They had already checked with neighbors or whoever. They knew. The neighbors knew. Police officers knew who responded. Torres' family knew. They all knew about the abuse. Dr. Harper testified that abused women act differently when they perceive a threat. I think Sarah Boone was loyal to a fault to George, even through all the abuse.
Gross. Gross.
Judge, I want to make a comment about a couple of things that were said by the prosecutor in opening statement.
Actually,
Oh boy.
The prosecutor in opening statement, when he was talking about George Torres passing away, he started talking about Sarah Boone. And his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torres deserved it. George Torres deserved it. That's the position to take it. He deserved to die. She loved the man. She wasn't trying to kill him. He also commented about
yes.
Yeah. I mean, dear God. Okay. Oh, I just noticed something. Hold on, let me back it up a second. I just noticed something, guys. Oh, wow. Look at this. Hold on. He's wearing George's Ace Hardware shirt. That's something that I found really poignant in the last live stream. We went over all those videos. And in one of the videos, I hadn't noticed this before, but George is wearing an App State t-shirt, which is wild because that's where I went to college. I have no idea how he got that, but I was like, holy shit. But then another time he's getting arrested, he's wearing the Ace Hardware shirt. But in then one of the last videos with the police body cam, when they're up there upstairs and they're helping him pick out an outfit to wear, and he specifically wants to wear his Ace Hardware shirt, and the law enforcement officer actually says, "You want the Ace shirt?" And he's like, "Yeah, that's the one I want." Like that was, oh my God, it's heartbreaking. Like he was so, even when he's being arrested, that was the shirt he wanted specifically because he was so proud of working there. He wanted the Ace Hardware shirt. But there's his brother wearing George's favorite shirt. So, wow. And there's Detective Copsel also right there. All right, so let's go back forward.
violent nonsense, violence, the violent episodes. It's a bunch of violent nonsense. Was his statement to you in opening statement? All this here, the photographs.
Yeah, violent nonsense.
It's a
is
bunch
great.
of violent nonsense. You'll have to make your mind up what it is. There were a couple of exhibits that I introduced late, and they were no contact provisions, where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for George Torres not to have any contact with Sarah. Okay. Court system got involved. We would have no contact with George Torres. Now, I need to talk a little bit about that. And they talked about coercion, coercive control, power control, power control. We know about his abuse. We know he destroyed the home, the TV. We know about his jealousy. You know, some of the things he said to her. We know about how he treated her dogs. Nicely when he was sober, but at times.
I mean, how many
using others
times?
or threatening
How
others.
many times does Sarah say he loves the dogs? He loves the dogs. Dancing with the dogs, you know. Yeah, are you referring to the shirt, Candace? I would imagine. I mean, yeah.
If you think about power control, when you're controlling a person, and I think she testified that he kind of smothered her, always around her. Part of his fear was her realizing that she had enough and to leave it for good. That she would get the strength over time if she had enough time away from him, where she wasn't in control of it and he wasn't in control of it.
I mean,
Enough time away.
I think that Ace, if there's one thing that Sarah didn't lie about, you know, she said, well, she used it as a way to be condescending in her interrogation, but she said, you know, George loved that job, blah, blah. But then she was like, but he sucked at the job or whatever. Anyway, but I think George did love that job. And I think it was the one thing he could be proud of. And he was really proud of it. Like the fact that he wanted to wear that shirt. Oh my God, it's hard for me.
She would come to her senses and realize she could do better. Judge has been getting points all week. I didn't stop George Torres. George Torres knew he was going to lose control. If she had a bunch of time away from him, she might move on. He was willing to violate a court order to maintain control.
No, she
That's
called
what-
him and told him to come over.
I want to show a couple of videos. You know, I'll say something to you. Show me if we're just going to have to. If we get dim the lights.
Yes.
Do you understand? As of this moment, and until I can get you out, get the fuck out of here. I dare you.
Did you see
Yeah,
this?
look at it. Wait, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
Did you see him flip the switch? In that instance? Where he lost it? Even though the video was going.
But that just disproves
Show the next one.
that just disproves what you were saying before, Owens. Even though it didn't make sense anyway, it just proves it. It proves it. Yeah, the video's going. I don't understand. Why is he contradicting himself here? Again, it was nonsensical anyway, but it's also now he's just contradicting it. And the thing about this TV is we know from these text messages, I think that's part of the reason they brought those in the state's rebuttal. We know from the text messages that the TV was broken because she wanted Brian to come help her fix it. So, you know, it makes you wonder if like maybe they thought it would be funny if he videoed this. You know, him just like some people, they might all have a dream of taking a baseball bat to a TV, right? Or something like that, right? But you would never do it. But it's like now there's an opportunity. But what you'll notice is he doesn't seem angry. Like he's hitting the TV, but he's not yelling at her. He's not threatening her. I don't think he really says anything while he's hitting the TV. It just seems like he's trying to smash up the TV, right? And I'm wondering if it's because it was broken anyway. And he could have been frustrated, you know, maybe there was frustrations about his life. Or it could have just been, you know, again, he's not really acting overly emotional. It could have just been, you know, it's like every little kid's dream would be to smash up a TV. I don't know, you know?
Thank you. Thank you, Judge.
Like, as you know, like it's fun. I mean, there's channels on YouTube that all they do is like destroy stuff, you know, and see what happens when they destroy it.
Can you turn it? Ladies and gentlemen, I'm going to finish up right here. And Sarah Boone, I've gotten to know.
Objection. Other argument.
Yeah,
Sustained.
yeah, no. We're at 20
Sarah Boone is
objections.
like any other citizen.
Oh, I
Equal
know.
justice under the law. She should be treated like any other citizen. Fairly and impartial. Based on the circumstances she was facing at the time of this tragedy. Based on the battered spouse instruction, which is a special instruction that's given when women have a heightened sense of fear and trauma, that you're utilizing in applying her subjective standard to the reasonable standard of what a reasonable person would do under her circumstances, and using the force that she used to defend herself. I hope I haven't missed anything.
Oh my God.
Try my best.
Oh my God. This is a strong finish.
Sarah Boone fought back and survived. We ask that you do justice in this case and find her not guilty because the doubt is reasonable. I tried to show you where the doubt was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you. We appreciate your service and your obligation to do your duty.
It was a
You
short
have the power
trial
and authority
relative
to
to
write
the
this
jury
law.
selection.
That's what we're asking you to do.
Although
Give Sarah Boone some
the
hope
jury selection was delayed countless times because Owens and they were arguing. So there's that too. It did delay it quite a bit.
for a better life and for you.
Yeah, he's done.
Yes, sir.
20
Any
objections.
rebuttal? You may proceed.
In total, grand total, 20 objections. Now we're on rebuttal. He's like, get your shit out of here. Yeah, dude. That just gives me goosebumps. That just gives me goosebumps, man. Because what did they do when Mr. Cacciatore started? First thing, get that suitcase out, put it right there. Then it gets put away for the defense. And the first thing gets that suitcase. Powerful. Wow. Wow. It's like saying to Mr. Owens, you will not stop this jury from seeing the truth. And the truth is this suitcase right here. Wow. Wait, hold on. Let me back that up. The sound. The sound. Wow. Let's it drop like that so they can hear it.
Ladies and gentlemen, George Torres is dead because the defendant believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her, when he choked her, and to hold him there as a captive audience, according to her testimony. Now,
And one thing I will note is that the rebuttal close is always, I think, probably the hardest because you have to be prepared. But the whole point is to rebut what happened in the defense close. And you never really know what they're going to say, especially Mr. Owens. I mean, that was, all over the place. So you kind of have to be prepared with what you're going to say, but be able to react, in the moment, right, to whatever they argued. And I will say, if you want to see a great rebuttal close from the state, go to the Ezra trial and watch Andrea, what was her last name? Nodolf for the state on the rebuttal close. That, to me, was one of the strongest rebuttal closes I've seen, if not the strongest. It was short, it was succinct, and it did all of the things. It addressed all of the points made by the defense, even though Mr. Nelson rambled on for like 3 hours. And it was brilliant. It was brilliant. I thought it was so good. So it's tough. Okay. Now here's the other thing. If you've got defense closing arguments where they didn't really make any good points, it's going to be harder to rebut, right? Or if the points just don't make sense. I mean, I guess you can still try, but in other words, in some ways it might make the job harder when the defense closing argument is all over the place and a huge mess. And again, could be part of the strategy that Mr. Owens had, again, not to give a good closing argument, right? But to be a mess, to be all over the place, make it harder to rebut. But also the biggest thing of all, I think, was, for me, in my opinion, was to take up time, waste time, filibuster. So
he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means viewing pornography. Well, we saw cheating really means women. And the heated conversation on June 14th about these women in Facebook, that's what leads to the arrest on June 15th. He's out whoring, Candy Crush, all the bizarre things that you see in her phone. She uses the legal system as a weapon at times. There's no denying that they are engaging in violent behavior, and it is over nonsense. It is smashing TVs. They call the police, and then they're standing there looking bewildered about what to do and who to say, and laughing and joking. Ladies and gentlemen, the courtroom is a place for justice, not a suitcase. The reason we have a
Very interesting tie he's got there.
jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim. So it developed into a system where citizens would have to say, yes, you can take our fellow citizen. But the opposite is also true. A citizen cannot take another citizen's life because he or she feels like it. That likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence and caution. Like Mr. Cacciatore argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still laws in place about when and how this can be done in a justifiable manner. I want to talk about the most important jury instruction in this case that has not been discussed very well or thoroughly. Excuse me. However, the use of deadly force is not justified if you find that Sarah Boone used
Hold on. I wanted to show you. Look, we got a good view of the ELMO here. Look at that ELMO. How cute. Go ELMO. Go ELMO.
However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And we'll stop at that comment. The facts of the case that came from her own mouth, if she is to be believed, and we will explore thoroughly why you should disregard every bit of her testimony, from court to the detectives, to the 911 operator, to the doctors. Her testimony, if it is to be believed, the most favorable light that she has presented of herself, is that at the end of a Sunday fun day, where we are drinking, we're outside by the dartboard, we're doing puzzles, we're doing arts and crafts, and there finally comes a point in time where we're gonna play hide and seek. And he says, Tag, you're it. Even though she's it, she goes upstairs, hides in the shower, eventually gets tired of being there, it's cold, so on and so forth, and she comes back downstairs. And as she comes back downstairs, she can see Mr. Torres fiddling to place himself inside the suitcase to try and hide for this game. And the lid is not closed, it's flapping. And out of jest, out of levity, undisputed according to her testimony, she comes over there and zips it shut. Whether it's 100% or enough for 2 fingers to get out, that is something that you decide as the jury. But there came a point in time where the fun and games was over. And Mr. Torres told her that. Babe, I can't breathe. Sarah, babe, let me out. This is all on video. We don't have to imagine this. This is all on video, 1062. At that point in time, she is using force against him that is not justified. She is the initial provocateur. She is the aggressor under the law. And what level of force is it? I can't breathe. Not let go of my hand, not get your hands off me. I can't breathe. This is no different than 2 people, maybe their buddies.
That's a really good point, right? Because like with the hitting of the bat and all the other stuff that she says, he's not saying any of that. He's only just saying, I can't breathe.
Are similar to an example given by Mr. Owen, who are wrestling, and one has another one in a headlock. And there comes a point in time where the person on the receiving end of the headlock says, that's enough, I'm tapping. George Torres was tapping, and she ignored it. And she was kind enough to tell you why. Out of anger, which translates to hatred, ill will, spite, just like that in jury instruction for second-degree murder. She told you exactly why. She got angry. Him saying, I can't breathe, babe, was what triggered her. Not a fear of imminent harm. Those are her own words. That is the law. These are the 2 paragraphs that solve this equation without getting up on a big whiteboard in college that's 30 feet long, 15 feet high, and a ladder, and somebody's scribbling Latin words and Greek letters for months and months to solve this huge, complicated equation. The equation is solved in 2 paragraphs.
What?
She is the initial aggressor. He is saying, I can't breathe. It is no different than a naked chokehold that she does not let go of. And she told you it's because I want him to listen to me. This is my bully pulpit. This is how he made me feel in the past. She doesn't describe it as teaching him a lesson, but that's exactly what she says. I want him to feel like I felt in the past. I want to tell him things. Ladies and gentlemen, we can play semantical games, but that is teaching him a lesson. Therefore, we have to look at the other two paragraphs. Because right now, plain as day, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threat and use the force against herself. And what force are we talking about? Well, the threat of force that she tells you she was facing was him fighting for survival, him sticking his fingers out of the suitcase, him sticking his hand out. That is the threat of force, coupled with, I'm going to end you. Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold, at least until we're separated. He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of two things. And she did neither. Not even close. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution. The state of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt. But a reasonable doubt is not an imaginary doubt, a forced doubt, speculative doubt. So accepting that all of their past history, accepting the doctor's testimony and the limitations on what they reviewed compared to what we reviewed. We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist and saying that he will end her if he gets out, we'll give her that. But just like Mr. Cacciatore mentioned earlier, lawyers, words mean things to us, and they mean things to everybody, but really to us. Or an and. There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on George Torres.
So,
She did
this
not.
is like I said earlier in the Mr. Cacciatore's opening. I wonder if he's going to bring up the fact that she had the phone and she did not call 911 or call for help.
Use every reasonable means to escape the danger that now, after provoking him, that he was presenting to her, according to her. She didn't pick up her cell phone and start walking. Call 911.
There it is.
She didn't do anything other than, if you believe that is why she called Brian Boone, made a phone call to Brian Boone, and unfortunately, because of past history, he just ignored her drunken phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this. Other than using the deadly force on George Torres. Now, this is a weird situation. This is not a rear naked chokehold. This is a suitcase, or as Mr. Cacciatore said, box, or actually more aptly described it as a coffin.
Yeah.
And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance. I'll give you a quick example from a couple of movies that I love.
Oh no.
In 1977 in May, a movie came out. It's called Star Wars. They eventually called it Episode 4. In the first scene, there is this large, imposing figure that wears black armor. He is a government agent, and he is looking for some stolen classified documents. He picks a man up who he believes is responsible for this treachery and breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force we all understand. But what we need to understand is the force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came out in 1977,
The thing is,
another-
I don't think you need this as an example. This is what he always does. He always gives these examples or these analogies when really the best example he can give is just describing the facts of the case, what happened.
the co-employee of this dark, imposing figure, Vader, insults his religion. He does not go to HR. He takes matters into his own hands and chokes this person from a distance. Ironically, while we're talking about force, it's the force. And then in the subsequent movie, he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force can be exerted from a distance in this situation. So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him. She has not exhausted every reasonable means to escape this danger. Do something. You started this. You put him in the position where he cannot breathe. She's required by law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed the threatened use of force. That did not happen. She never withdrew from physical contact. She is still, like Vader, choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on George Torres' movement. She never indicated that she wanted to withdraw. Sarah.
According to Mr. Owens, Sarah Boone is like a law enforcement officer, like a cop. like a Vietnam vet. And according to Mr. Che, she's like Darth Vader.
Hey, I can't breathe. All right, if I let you out, are you gonna come out peacefully? Since I started this, I'm the one that made you not be able to breathe. That didn't happen. So ladies and gentlemen, this entire analysis about deadly force starts and ends there. She was the provocateur. These are her obligations when she starts it. She put him in fear of death. He is literally telling her, I cannot breathe. A couple other things about the law. Second-degree murder does not require a proof of intent to kill. Argument was made repeatedly that she didn't intend to kill him. That has never been the state's suggestion. Because why would we suggest we prove something that we don't have to? It's not her subjective belief. Well, Sarah Boone doesn't believe that this suitcase can kill him, even though he's repeatedly said, I can't breathe. It's a person of ordinary judgment who would know is reasonably certain to kill or do serious bodily injury to another. A person of ordinary judgment who hears, I can't breathe, babe, Sarah, and his voice gets weaker 9 minutes later. You're on notice. This is statutory notice. Done from ill will, hatred, spite, or evil intent. Her words speak for herself. This was not out of fear. This was out of hatred and anger. Born out of all those horrible things that has been done to her and done to him. Understand, we're not going to belabor the past. Is of such nature that the act itself indicates a difference in human life. I don't care that you're saying you can't breathe. Fuck you. That's my name. Don't wear it out. Fuck you. It's second-degree murder. We do not have to prove the intent to kill. We have to. She intended the act. She intended the act of zipping him shut. She continued to intend that act when he said, I can't breathe. That act resulted in his death. That's a manslaughter, but then when you add in the hatred, ill will, spite, and the depraved mind, that's what makes it second-degree murder. And that 2-minute video is the textbook definition of depraved mind as we define it here in Florida. Voluntary intoxication is not a defense. You cannot feel sorry for her because they had 2 1.5-liter bottles of wine and then some from the leftovers from the day before. And quite frankly, she's blackout drunk. She's blackout drunk. She doesn't remember making the videos. She turns her phone over right to the deputy the next day because she doesn't know what's on it. She doesn't remember doing it. Another thing that we just haven't talked about much is her story. She can't be up in the shower hiding and taking a picture at 11:03 p.m., 9 minutes before the video. That portion of her story just doesn't add up. And what it shows is it's more like 20 minutes instead of 11 or 12 minutes that we know he's trapped in what turns out to be his coffin. Let's talk about her testimony at trial. And we'll talk about all the problems. A lot of her issues predated her relationship with Mr. Torres. So it's not attributable to the trauma from Mr. Torres with all the luggage she brought into the relationship. And listen to the way she talks. It's not splitting the bills. It's helping without argument. It's not cleaning up and doing Sunday chores. It's cleaning up so we can relax. It's a reward. She talks about him like he's a child. I need to lead him to the next activity from one to the other. And then you saw all the videos, and I'm not going to belabor it, that we showed in rebuttal, but the relationship and the power dynamics speak for itself. He was treated like the third dog. And it might very well have been a dog that bit and was violent, but he was treated like a dog. Why are you leaning against my door? Get out of here. Go downstairs. You're worthless. You're garbage. They showed the part of the video where he slaps the phone, but that's after 5 or 6 minutes of being berated and dehumanized in a way that nobody should be treated. He just wanted to get in bed and lay down next to his fiance. Instead, get away from the side of my door, you useless dog. I thought it might be a good point in time to listen to the music. You know, when does Mr. Torres get to decide what to do? I mean, she paints this picture that he goes off and does all these things on his own, goes and buys wine when he's not supposed to, does all these things when he's not supposed to, but when does he get to do what he wants? Suitcase downstairs for a week so they can donate it. What was in their lives that was preventing them from getting that suitcase to Goodwill or whatever? Neither one of them worked. What's going on? Lucas is over there on Mondays and Tuesdays. The story about the suitcase having already been down there is quite suspect, and we will get into that more. But again, it's not we went on a trip together, we had a great time. It's I quote unquote, I recently took him on a trip. Then it comes down to the moment of truth, which we've already gone over. And it's just quite frankly inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs. There's a major glitch in her matrix. She shakes the suitcase, please stop doing this to me. And then his hand gets out. Now she's the point in time when she gets angry and doesn't do what the law requires after basically choking him with his coffin. Beats him into submission with the bat and turns it back over. For the first time ever at trial, she says, I'm going to fucking end you, is what he said. She never told that to even her doctors. We've heard arguments why she didn't tell the truth to the police and all that.
Something out real quick. First of all, I think that the coffin would be more effective if you didn't use it as often. I think it's losing its impact with repeated use. Second of all, I appreciate that he got that quote right. I've pointed this out several times, how Sarah on the stand says, I'm going to fucking end you or whatever, right? And then Mr. Owens doesn't quote it correctly, and neither does Sarah later on when they're both referencing it. And it's been driving me crazy. And even in his closing argument, Owen misquoted it. And we watched her on the stand for that live, and I remembered what she said. And then I pointed it out at the time. And I was like, how come I'm remembering what she said and she's not, neither is Jones? Well, thank goodness Mr. J is actually quoting literally what she said. It's the first person who's done that since she first said it the first time, apart from me.
And there's a lot of truth into the argument that was made. There's a lot of truth. When the argument is made that she didn't understand self-defense, what that means, what it comes across as, she makes the story change as she learns about it. When we apply the jury instructions to her statement, all 6 of them apply against her. Won't belabor this since it was discussed earlier, but did the witness have an opportunity to see and know the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot, but she was so intoxicated that she still felt the effects of it at 1 PM the following day. The medical examiner told you that alcohol dissipates in the average person. Everybody's different, tolerance, all sorts of things come into play, but on average, 0.015 grams per deciliter will dissipate every hour. So you can do the math. 0.015 times 14 puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police. You should not believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03. You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding. Does the witness seem to have an accurate memory? Well, this ties into what we're talking about. But again, there's a glitch in the matrix, 11:03 to 11:12. Her memory is not accurate. By her own admission, I don't remember. She tells the police when they show her the video, I don't remember that happening. Was the witness honest and straightforward in answering the attorney's questions? I submit when we got off script, and by we, I mean with both attorneys, she wasn't as honest and straightforward as when it was a very directed and smooth examination. I came out of the gate with something that was off script. Tell me about Pamela Erickson. Tell me about Christine. Tell me about Crystal. Because she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were and that she believed that he was cheating on them with her. And apparently she is too with some guy named Ben. That when I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real. But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Object.
Approach.
Let me say it loud and clear. Bad spouse syndrome does not have any effect on this case. It has no relationship to this case because she is the aggressor. She zipped him shut in the suitcase after he said, I couldn't breathe, she wouldn't let him out. Therefore, all of the instructions above that paragraph of however do not apply. They do not apply. Now, turning back to what I was saying, did the witness have some interest in how the case would be decided? Well, of course. 3 out of 4 panels that y'all came from indicated to the judge fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend, as you should, because all 6 of these things, we haven't gotten to the inconsistent statements. Let's pretend her testimony doesn't exist, and you just have to look at the circumstances.
I do like that he pointed that out. You don't have to accept her story. He's giving them permission to admit to themselves that it's not believable. You know, I think that's good.
The testimony from the defendant is
This
George Torres' head
right
is
here.
here. You can stand if you need. You've been sitting a long time. His head is here. His butt is kind of down here. His feet are here. And his hands and his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back are on his left side. You hear that? That's solid. You don't have to accept that she put those marks on him when he was in there. The evidence doesn't support it. You can conclude she used his bat when he was outside the suitcase.
I thought that was a great
You don't have to
demonstration.
believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie. She can't expect you to believe her testimony about the loud boom being the day before compared to her two neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in
Now
common.
that part I don't
Did she have
quite.
any injuries consistent with being dragged?
That part confused me because I don't know what 6 infirmities he's referencing there. There's some strong parts to this. I think that suitcase demonstration was brilliant. I also liked physics doesn't lie, but then he didn't follow that up with what he meant by that in terms of how that is applicable. And then, so this is kind of hit or miss for me. It's not as strong as Mr. Cacciatore, but I do love that suitcase demonstration. I think that was maybe one of the best parts for me of his rebuttal close.
Up and down the stairs the night before. No, you saw the pictures the CSI took. You don't have to accept her story about hide and seek. Something made that loud boom. It takes energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the evidence supports, is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. It's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be, how you're going to live your life. Go take a walk. Do this. Do that. You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happen outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't. The inconsistencies, I'm not going to belabor it. Your dinner is waiting in back. Let's just briefly talk
I
about
love that
this.
moment too. That was
Move on
great.
to the end. Dr. Brandon was absolutely fantastic. He explained everything that you all needed to know about battered spouse syndrome. And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor, and she had the duty to do the things that the law requires. But it does call into question
And he's the one that's
credibility
dead.
of the past power dynamics of their relationship. Those videos speak for themselves. The officer in the last video asks him, dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? He's like, man, I'm not a beefcake. I'm not going to rat her out. There's countless examples, if you apply Dr. Brandon's testimony to Juan Torres, that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper.
That was
I don't
my
find
other
much
favorite
moral with what
moment.
she says about battered spouse syndrome, and nobody should. I mean,
That
she's
was my other favorite moment. He was her violent pet. Was brilliant. Brilliant.
the expert, but she's not Ms. Boone's treating physician. She's not her treating psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm. That's the crux of the matter, Doc. You're never going to ask her what it is he said or did for this grand jury instruction about threat of force or use of force? It's remarkable. And, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power to stop him from dying, because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop. She didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded that spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees, yes, Ms. Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't. After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations. There's details that matter. And again, not to belabor it. I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter of as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very edited clip of him attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos. Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes. You'll see the rest of the text messages if you choose to delve into them, but I would suggest you don't have to, given the jury instruction about aggressor. Ladies and gentlemen, this has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torres and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense that I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires her to stop using the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. And you know what was in her heart. She tells you it's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him. She did, and then she left him there. And she had an obligation. If you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
Thank you both.
Good. Very good.
Members of the jury, I have some additional instructions to read to you. You would be so kind to turn to page 21 of 22. Instruction 3.12, verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. If you're looking for it, if you don't have it, I do. That's why we only have one. The verdict form reads, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, case number 48-2020-CF-00260-3-O, State of Florida plaintiff versus Sarah Boone defendant. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this blank date blank, 2024, signed, foreperson. Final instruction, members of the jury, page 22. Instruction 3.13, submitting case to jury. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. All exhibits, with the exception of Exhibit 10, which purports to be a wooden baseball bat, will be sent into the jury room with you when you begin to deliberate.
That includes the
If you wish to
suitcase.
see Exhibit 10, which purports to be a wooden baseball bat, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply in this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Parties approach. Your participation in this very important process. As I said to you last week, be it Monday or Tuesday, maybe even on Wednesday, without your sacrifice and your service, the wheels of justice would simply come to a screeching halt. And on behalf of myself, the state, the defense, and Ms. Boone, we thank you for that sacrifice. With that, jurors wearing badge 295, 9, 569, 515, 130, 249, and 448, and 110, you successfully served as our alternate jurors in this trial. I wish I could give you more than my thanks and a hot meal that's waiting for you, but I do thank you for your service and your sacrifice. Courtroom deputy is going to take you out this time so you can collect your meal, and I'll meet you back there momentarily to give you your jury certificates. Thank you for your service.
All right. On to the
The
verdict.
rest of y'all, if I didn't call your badge, you need to hang out.
Where is it? Thought I saw it. They're bringing the suitcase back. I don't know why the verdict. Hold on, let me find. This was not in the stream. Hold on, let me find that.
Second degree as charged in the information. So say we all dated at Orlando, Orange County, Florida, on this 25th day of October 2024. The form has been signed by the full principal.
Madam Clerk, please poll our jury.
Juror seat number 1, is this your true and correct verdict?
Yes, it is.
Juror seat number 2, is this your true and correct verdict?
Yes, it is.
Juror seat number 3, is this your true
Yes,
and
it
correct
is.
verdict? Juror
Wow.
seat number 4, is this your true and correct verdict?
Yes.
Juror seat number 5, is this your true and correct verdict?
Yes.
Juror seat number 6, is this your true and correct verdict?
Yes, ma'am.
Members of our jury, again,
There
I want
it
to
is.
thank you for your time, your sacrifice, and your attention in this matter. I know that we spent almost 2 weeks together, and it was not taken lightly, and I really appreciate the time and the effort and the sacrifice that you put into this case. I want to advise you now of your final instruction. Members, ladies and gentlemen, I wish to thank you for your time and your consideration in this case. I also wish to advise you of some very special privileges enjoyed by.
Okay, so now what I'm going to do is I'm going to skip to, so there was, the press conference afterwards and stuff, but there was a interview with, where'd it go? There was an interview with, hold on just a sec. Oh, hold on. Is this the right thing? I think this is the right thing. So there was an interview with Mr. Owens that they did on Court TV where it was a longer interview.
Jurors. No juror can ever be required to talk about.
Hold on. It's not sharing. Sorry, hold on. It's not sharing the right thing. Hold on. Let me fix this real quick. Okay, hold on. Okay, here we go.
Sarah Boone found guilty of second-degree murder in the Suitcase murder trial. Big verdict on this Friday night here on Court TV. We're going to take you straight down to the courthouse in Orlando. Kelly Craft is there with Sarah Boone's attorney. Kelly.
Hey there, Vinny. Yeah, it didn't take very long for the jurors to return a verdict in this case. Sarah Boone guilty of second-degree murder. We are joined now by her defense counsel, who advocated for her vehemently throughout this trial. This is James Owens. James, what's your reaction to the verdict?
Just disappointed. Sarah's devastated. She's disappointed. We felt like we had a good defense with the facts that we had. Obviously, we had some hurdles to overcome for the state's evidence. And for whatever reason, the jury didn't see it our way. We respect the jury's decision. I'm sure that Sarah Boone is going to want to appeal. I believe that she does have potentially 2 or 3 good appellate issues. So the next thing in store is I think we've got sentencing set for, I believe, Monday, December the 2nd at 1:30. And we intend to call Dr. Harper as a witness to speak about her other mental health issues that she struggles with, and hopefully the court will consider that.
Mr. Owens, Sarah Boone was offered a plea deal in this case, manslaughter. She did not take it. What do you think now, having the verdict?
Well, ultimately, that's their decision. You know, they've got a couple of fundamental decisions. One is whether to plead guilty to anything, and the other is whether to go to trial, and the other is, whether to testify, and then the other is whether to appeal. And so Sarah Boone maintained that she wanted a trial the entire time, and we did discuss, there were plea negotiations, and there were offers on the table for the lesser charge of manslaughter, but Sarah ultimately rejected those offers and wanted her day in court.
She felt, it seemed throughout this entire trial, she seemed to be very upbeat. It seemed, though, I was getting the sense she really felt she hadn't done anything criminally wrong.
Well, I think, I believe she's a better spouse, and I believe she believes she's a better spouse. Once she learned, and we gave her a bunch of material about the subject, once she learned, what she had gone through with George Torres, I think she believed she was a better spouse. So we believed in that scenario that she was justified in defending herself. And so she felt good because she had a defense and she had lawyers. Initially she was going to represent herself, and then she did that for a while. And I think she appreciated the fact that we came in, myself, Tony Henderson, and Kevin Beck, and then our team. We had 5 or 6 people working on the case for the last 45 days trying to get ready for trial. And I think she appreciated our efforts. She knew we were working hard. I've been here in Orlando for 3 weeks, and then the rest of the team's been here for 2 weeks. So we've been doing everything we could do to represent her to the best of our ability, and that's what we did with the time that we had.
You really put up a good fight. Were you surprised that the jurors came back as quickly as they did?
I was. I think that the rebuttal evidence where they played a bunch of videotapes of off Sarah's phone, where there were some interactions with Sarah and George, I think that affected the jury.
What do you think another big challenge was for you in this case?
Well, of course, the suitcase video is difficult to deal with. And then, her interrogation, the 2-hour interrogation at the sheriff's department. So, we have evidence. That's probably the best evidence in a case, is the videotape oftentimes is the best evidence. And, we had some big hurdles to overcome. And obviously the jury, and I respect the jury's decision, saw it a different way than we presented.
During your closing arguments, one of the things that you talked about was we're in 2024, and the perception that the state may be trying to give that she, in a way, deserved this, that she was the aggressor. You talked about how men are taught not to put a hand on a woman. I thought that was pretty powerful. I thought that was going to resonate a little bit more with the jury.
Yeah, I think that, it was a long trial and the testimony came out. The state got in a bunch of evidence about, like I said, the video interactions between George and Sarah. And some of that, it seemed like Sarah was berating him a little bit and talking down to him a little bit. And, the state had argued that this was a mutual abusive situation, that Sarah verbally, emotionally maybe abused him. So I think there was some of that going on in the relationship. It was a dysfunctional, toxic relationship. Obviously, those two didn't need to be together, but they, for whatever reason, they could not stay away from each other. And even when she had been battered multiple times by him over time, for whatever reason, they couldn't break up. And it just, I think everybody around, law enforcement, the neighbors, family, all knew how bad the situation was, but for whatever reason, they were drawn to each other and couldn't let go.
The judge made it clear before the verdict was read that he did not want any outbursts in the courtroom. We had one earlier from George Torres's family. No real reaction from Sarah Boone. I just saw her talking with you, but obviously, as you were mentioning, seems to be not very happy, devastated with the verdict.
Yeah, she couldn't believe it. We were optimistic. We were optimistic, and I understand, these things happen, and there's some murder charge. So, somebody died. So it's difficult for a jury sometimes not to come back with something. And they came back with the highest charge. I was hoping maybe for something lesser, but we understand. Sarah's in shock. It happened, and then she was escorted out of the court.
This is one of the things that I thought was so surprising, is how many times he says that she was in shock. It just goes to show you where her mind's at.
Fairly quickly, so we really didn't get a chance to talk that much. She said she would call me tomorrow. I'm going to be driving back home, and we'll talk. I'll be on the road for 6 hours, so we'll talk for however long. But I explained to her she had a right to an appeal, and she had 2 or 3 good appellate issues. So I told her to keep her head up.
Mr. Owens, you were not her first attorney. She went through several attorneys. How was she to work with?
She was fine. I think once she realized, it wasn't just me, and I spent a lot of time down here with her. And then once she realized Tony Henderson really helped me out a lot with Sarah Boone. And, I've represented some difficult clients. I've been doing it quite a while. But Sarah, was, of course, she didn't want to give up the power because she'd had the case for 4.5 years. She had so many different lawyers. So, but I think once she started to trust us and realized that we really cared about her, we really believed in her, and we wanted to do everything we could to fight for her, I think she finally, it didn't take too long for her to develop a sense that we were really genuinely trying to help her. And I think once she saw how hard we were working and everything we were trying to do to help her, we didn't have a problem.
And you got involved with this case because you saw that she had taken out an ad.
Yeah, as you know, the court had ruled that she forfeited her right to a lawyer, a public lawyer. And so she was going to have to represent herself. And I think she went to a couple of hearings and realized that that's a lot harder than it looks. And that's when she had reached out for somebody in the private bar to take the case. And I came down and visited with her, and I agreed to do it. So we were in it to win it. We tried everything we could do to present the case in a fashion that the jury would consider her side.
I think one of the biggest moments was when you got the expert of the states to talk about the fact that she did believe that Sarah Boone suffered from battered spouse syndrome. I thought that was going to be a big game changer for you.
Well, it was. I've got some disagreements about how that was all handled because she came out with an opinion that she had never expressed before.
And then you had to conduct a deposition right there in court.
Yeah, I've never had to do that. That was a first, but it was a unique situation. Of course, the judge had set a date certain about trying the case. So I had the case for about 45 days, but we tried to schedule Dr. Werner's deposition. I believe we took it on October the 4th. And then later on, she came up with another opinion that I wasn't aware of until in the courtroom. And so the judge allowed me to take a deposition. I never heard of it happening before. First time it ever happened, but it did. And, we did the best that we could to counter that and then to cross-examine her. But yeah, I think initially she had said she hadn't made up her mind about it. But I think after a little bit of time, she decided to go ahead and give the opinion that that Sarah did suffer from battered spouse, and that corroborated what Dr. Harper had said, that she did suffer from battered spouse syndrome. So I guess that was a good of that.
Any thought in hindsight that maybe there was a motion to eliminate for you not to use the battered spouse syndrome defense, to not talk about self-defense? Obviously, you got to be able to do that. The state was very clear. She needs to say there's an overt act. She eventually did. She said his hand coming out of the suitcase was that overt act. In hindsight, could there have been another strategy that you could have taken that could have been more successful? Maybe not argue battered spouse syndrome?
No, I don't think so. I think, you know, what she was saying in that 2-minute video to George while he was in the suitcase, I'm convinced was tied to the trauma that she had received from the abuse that she had suffered from George. And I just think Dr. Harper, you know, it's a complex syndrome. It really is. And it's difficult for lay people to understand. I've tried to talk to, you know, the psychologist, the psychiatrist about it to try to understand it. You know, why somebody wouldn't leave that situation. Why, you know, if they're getting beaten up, they're getting stabbed in the leg, why wouldn't you leave that situation? It's
crazy to think that he is saying he doesn't understand that. Like, what, have you never heard of what these DV relationships are like? Like, that's wild.
One of those things, it's a head scratcher for a lot of people.
Yeah, I don't think that's the case anymore. Maybe like 20 years ago, but like, I don't think people are confused about that anymore.
So that's the reason you bring in expert testimony, is to try to explain that to a jury, what was going on. But it's difficult for people to really understand.
When Sarah Boone refused the plea offer, the judge made it very clear to her that the minimum he could sentence her to would be 22 years in prison. Is she prepared for the sentencing that's going to be in December?
I don't think she's prepared. I don't believe that. You know, I think she was in hopes, you know, she was excited about us and she felt like she had a defense and that we were doing everything.
I found that really interesting too. He says, I don't think she's prepared. So a lot of this that's coming out here, we didn't hear in the other initial like press conference, you know, with them. That is really interesting. He doesn't think she's prepared. Like, that really shows, it's one thing to be like shocked by the verdict, but it's another thing to be like, she's really not prepared for the sentencing. It's like that's a lot to say, right? I don't know that I've ever heard an attorney say that about, you know, a defendant when they're found guilty, because usually they at least have sort of considered that there's a potential they could go to prison. It's crazy.
And she had the experts lined up. So I don't think she was thinking about this at all. I think she was very optimistic. That's why she was optimistic during the trial. She was.
So for him to say this to me, it means this is probably even understated from what it is, right? Like, for him to say it at all, it seems like to me her shock at the verdict and her unable to accept that she's going to be going to prison for a lengthy period of time is even more so than what he's expressing.
She was happy with us every day. She was happy with what we were doing. And of course, you know, she understood that it was a valid defense in Florida. Battered spouse, using it to justify the force that you use. So, yeah, she's devastated, and she hadn't come to grips. Like I say, I'll talk to her tomorrow, but she was just stunned today.
Vinny also has a question. Vinny, what's the question?
Yeah, I had a couple questions for James. First, at the sentencing, will this judge have much discretion in what the sentence can be? And do you expect Sarah to express any sense of remorse at sentencing?
At the sentencing, will the judge, Vinny's asking, at the sentencing, will the judge have any discretion? This is her first felony. The judge made that very clear. So that's the first question. And then the second question is, will Sarah Boone say something? Will she express any sort of remorse for what took place? Will she make a statement, an allocution at her sentencing? I know you have to take some preparation time for that.
I think the prosecutor had said the low end of the guidelines was 22 years, and I think the judge told Sarah that. So I think that probably is the minimum, unless there's something I'm missing, maybe a downward departure. I don't know that she would qualify, but you know, the judge has the range, and the judge has the discretion, and the judge, you know, is going to hear from the victim's family, and then the judge is going to hear from Dr. Harper, and ultimately the judge is going to have to hear from Sarah.
Good boy.
Boone about this. I don't know what her position's going to be, but we'll see.
Mr. Owens, thank you so much.
Thank you.
Nice work.
The question will be, is it going to be more infuriating than what Ezra said at her sentencing? That's going to be, I have no idea. I couldn't say. Maybe they're going to be tied. Yeah. So we will see. But that's it, I believe, for him on this.
All right, thanks. Appreciate it.
Benny, that's the latest.
That's it. So that's it. So what we're going to do next, guys, in terms of, coming up next. So tonight we have the next episode for the Casey Anthony trial. We will review where we left off, kind of took a little bit of a pause to cover this. So we will review sort of what was going on from the last time, get everyone up to speed, and then we'll have our next episode tonight. And then on Thursday will be the next live stream as it pertains to Sarah Boone. Guys, get ready for that, because what we're going to see, there's so much that didn't come in at this trial that was expected to come in, including Brian Boone's interviews with law enforcement. So we are going to watch Brian Boone's body cam with from that day of, February 24th with like first responders. And then we're also going to hear his interview with Detective Copsel. And then we are also going to watch Sarah's interrogation from an alternate angle where you can see all three people, and it's a much higher definition camera. And the other thing is that I've already realized that, so the last time we saw that interrogation, when we covered that from the trial, it was before all those videos had come out on day 5 with the body cam and with Sarah's phone videos. I have a whole new, I talked a little bit about it on the last live stream, what I think about the suitcase and what was going on with them. But there's a lot that happens in that interrogation that I know was hard to appreciate because we didn't have all the information. So basically, even beyond having an additional camera angle where you can see things differently, the questions that were asked, to me, resonate completely differently, because it's clear to me that the detectives had watched, because, she handed over her phone. They hadn't just watched the suitcase video. They had watched all those videos on her phone. They maybe didn't have the body cam, but they maybe did. But at the very least, they had the videos from her phone. And that becomes really clear in their questions. And it just shows, the context is completely different. Like in that interrogation, the context is completely different now that we've seen all those other videos. So I'm really excited to go through it again. I have a lot of thoughts. So that will be on Thursday, I believe, is what it's scheduled for. So y'all, thanks for being here. We did it. We got through another trial. This was a short one. But appreciate you guys being here. Love y'all. And hopefully see y'all tonight for Casey Anthony.